on this day, the 23rd of February, 2023. I also want to welcome the Public Protector. Hopefully they've joined. Temengos, if you can check that. Welcome evidence leaders, members of the media, this entire support staff of the inquiry, members of the public and their YouTube and 4A channels, but also to welcome back our witness, Mr. Rodney Mataboge. Before I proceed, we'll just quickly check the public protector and her legal team if they're on the platform so that we can start with them being present. So we'll just, for a few minutes, colleagues, going to delay a bit. Thank you for your patience.
Recording stopped.
Welcome, Public Protector and your legal team led by Advocate Mpofu. We're going to start, and as I indicated, Advocate Bauer would have started on Tuesday. I indicated yesterday that she's going to continue today from 10 and up to 1300 hours. So that we're able to manage our time that has become very tight. But before I go to her, Miss Fatima Ibrahim did raise that just before we proceed, that Mr. Mataboge wanted to just raise one or two things. I've agreed to give him that opportunity, and I'm now going to invite Mr. Mataboge to address the committee. But before that, I see a hand of Advocate Mpofu.
Thank you, Chairperson. No, thank you very much. I think it might be appropriate for me to say what I need to say after Mr. Mataboge.
Okay, thank you, Advocate Mpofu.
Thank you.
Mr. Rodney Mataboge, I now invite you to address the committee.
Good morning, Chairperson. I hope my picture is better today. I've requested, as Ms. Ibrahim has said, to start off by addressing the Chairperson and the committee. I wish to say good morning to the Chairperson and honorable members, as well as the PP and her legal team. I'm unfortunately going to have to take you back to what was happening yesterday with the message that I got the day before yesterday, which was handled yesterday by the committee and the chair. I just want to say upfront that I had felt compelled to share the message with the chair or with the committee other than anybody else. And the way it was handled, in my view, it was handled in a way that I'm not happy. In that after I had my misgivings and my concerns, then the very message that unsettled everybody else, and that message is indicting on my character, my so I have not even shared it with the other team of the PP, nor with my family. They only saw it when the chair displayed it in chambers. That the PP chair displayed it as a comment to say what was intended to be an attempt to protect me, exposed me more as an investigator. In that everybody now was calling.
Can you
Just pause, Mr. Mataboge, just pause. You seem to be cutting as you speak, and we're going to ask them to also try and fix the volume as well, so it's up a bit. Sorry for that, because we do want to hear you properly. Maybe you can just quickly start again, because there seems to be a problem with the system. I don't know what. Are we fine? Are we fine, ICT? Oh, we're fine on your side. Okay. Let's try it again, Mr. Mataboge.
Thank you very much, Chairperson. I was saying
That's much better. That's much better.
The message the day before yesterday, after the session on Tuesday, I then decided to share it with the committee and through Ms. Ibrahim to bring it to the chairperson's attention. And I'm happy that it was dealt with in the manner that it happened with the committee. However, I'm unhappy with the fact that having complained about our vulnerability and exposure as investigators, then the chair with the committee decided to share the very message that was damning to my character and as an investigator as well, shared with everybody else. And my family only got to know about the message when it was flagged in Parliament. I just want to put on record that that was very exposing and very infringing on my rights as an investigator. That is the point I wanted to raise as a first point, Chairperson, because I thought that I was supposed to be protected by the chair and the committee, especially after my address on Tuesday about the fact that as investigators who are exposed, who are vulnerable, and who are likely to be targets of some people that we investigated. That as far as the point number one that I wanted to raise is concerned. Secondly, Chair, on Tuesday, in my opening remarks, I talked about section 6, subsection 8 of the Public Protector, which I want to read out to the House for the record, if you allow me, Chair.
No. Go ahead.
The public protector or any member of his or her staff shall be competent but not compellable to answer questions in any proceedings in or before a court of law or any body or institution established by or under any law in connection with any information relating to the investigation which in the course of his or her investigation has come to his or her knowledge. So this is what I had based my concerns on Monday when I raised my, not Monday, sorry, on Tuesday, when I first made my opening remarks. So I want the chair and the committee to help me going forward to say, am I a comparable witness if one interprets what the legislature has put here for purposes of going forward? Because I'm not only speaking for me, I'm also speaking for those investigators that are still currently busy with matters. And if it is true that I'm a comparable witness, then it must be put on record that I'm a comparable witness. And so I'll then exercise my right in future to then review that decision that I'm a comparable witness, because I've not had a chance to seek legal advice, because I didn't want to delay the process and further inconvenience the people that are involved, including the PP in this inquiry. Thank you, Chairperson.
Thank you, Mr. Mataboge. Advocate Mpofu, you wanted to come in after him.
Chair, can you hear me?
Yes, I can hear you.
Thank you, Chair. I'll be brief. No, Chair, we just wanted to place on record our objection, our client's objection to the manner in which this matter of Mr. Mataboge was handled, and that 2 or 3 quick aspects about it. One is the issue of the public protector was excluded from the discussion, and you know, whatever the reason was, we thought maybe during the deliberations it should have been clear that that we should be participating in this, insofar as it concerns a witness who's testifying in the public protector's inquiry. The second issue is probably related to what Mr. Mataboge has just said now, and we were looking at as to the whether it was procedural to quote unquote subpoena him in the manner that he was subpoenaed. And we have found that the directives are silent on that question. They do prescribe timelines for witnesses that are called by the evidence leaders or ourselves, but not in respect of witnesses called by the or subpoenaed by the inquiry itself. However, as we all know, even though there might not be specified timelines, the issue is that everything that is done in terms of Rule 129 AD2 must not only be fair, but must be reasonable, taking into account, of course, that the committee must also finish its work without delay. So the question then becomes whether it was reasonable or not to quote unquote summon or subpoena Mr. Mataboge to come here within 24 hours, as it were, or less. And I think that links up with what he is saying about his expressed desire, and I'm taking this, Chair, from your report to us after the committee met in camera, that he had desired to obtain legal advice. And from what he has just said now, he has not yet been able to obtain that legal advice on the questions that he has raised, which I will not repeat. So, but for whatever reason that he required to obtain legal advice, it is our view that he should have been given a reasonable opportunity to do so, because that would have then avoided, among other things, the issues that he has just raised now. The questions that he's asking you, Chair, about his compellability or otherwise and so on, he obviously would have raised it with his lawyers and come here with a position one way or the other, rather than putting the committee on the spot as to that question. And also the risk of the committee proceeding without considering that question is obviously inherent. So we just, those are the issues that we wanted to raise, Chair, just to say that we are unhappy, to put it mildly, about the matter having been discussed without our involvement. We do understand why it would have been done not in the public domain because of the sensitivity of the nature of the matter. In other words, the exclusion of the media and maybe reporting to the media afterwards, but not ourselves as a participant, particularly the public protector, because she may have had something to say about what should happen. Also, even just as a person who is familiar with the relevant legislation that Mr. Mataboge has referred to, but more importantly, as the subject of the inquiry itself. I think she's the person most affected by this more than all of us, and therefore she should have been given an opportunity to participate when it became clear. Particularly, as I understand it, at some point the committee felt it necessary to invite Mr. Mataboge to address it while it was in camera, and that kind of process should not take place in the absence of the public protector or his legal representatives. Thank you, Chair.
Thank you, Advocate Mpofu and Mr. Mataboge. Honorable members, perhaps before I make a ruling, can I check with any member if there's a member who wants to make a remark or comment on what has been placed before us, both by Mr. Mataboge and the public protector legal team? No one on the virtual? No one here? Okay. Thank you, honorable members. I think let me just indicate this. I'll start with the presentation by Advocate Mpofu representing the PP. We all know the process and the proceedings that took place yesterday of the committee in the manner that we started, and would have decided to do an in-committee session for about 2+ hours. And that session would have involved us as a committee discussing collectively how we wanted to proceed from there, and the subject matter and the person directly affected by that kind of a discussion would have been Mr. Rodney Mataboge, which the committee gave him an opportunity to address it before I made the final summary and the ruling. And so that opportunity was given to Mr. Mataboge for us to hear him, which we did. Thereafter, after calling back everybody, I would have, can I ask Advocates Bauer and Mayosi you're very close to me, so when you speak, it's disturbing me. You don't seem to be able to whisper. So when everybody else was called in, I then summarized the decisions of the committee and informed everybody in this inquiry, including the public out there, about the kind of decision we went to, and would have taken them through everything else that we dealt with. At the end of that, I would have asked if there's anybody in the meeting who wanted to make a remark in that regard. There was none. Nobody was barred. Nobody was excluded from responding after being invited by the chair to respond to what I tabled on behalf of the committee. Then to go to the issues raised by Mr. Rodney Mataboge We note what you've just raised, that you're satisfied with the manner in which you dealt with the matter. It's point number one. Because we made an intervention on the spot, even before the meeting happened. As a chair, I would have instructed the secretary to interact with the person who was sending that text, and for that person to desist from what he was doing. And we further said whatever that was doing must be put on writing and sent to the committee. We then further, as part of how we, because I think you are raising an issue that you are not happy about, the fact that in the report back of the decisions of the committee were reflected entirely on the message that was sent to you. We did that because we felt it's important that we transparent to everybody, and also that is also meant to inhibit and make sure that people who do that beyond Mr. Mujaki do not do it. The committee was of the firm view that was at some point Mr. Mujaki was nameless. The committee was very firm to say he's got to be named and be known. And so it was the view of the committee that kind of message, which we felt impeded the work of the committee, needed to be reported back to the committee, to the inquiry, that everybody else, there's no hearsay about it. We did so. In our view, we thought that it is the correct way to do it. We still, as the chair of this committee, still believe that it was correct that we relayed that message and not just read it to be on record, but also flighted it as it is unedited. So that's a point about that. You then have read to us what you feel we should consider in terms of the PP Act. Just to indicate to you again that today, you, as we decided yesterday, you are here being subpoenaed by this committee. You under that process, and we will continue therefore in that regard, because that process that we entered into would even supersede what would have happened within the PP Act, given the fact that this is part of a constitutional task that went into a process. And so, and therefore, that's a legislation that cannot supersede what a directive of the Constitution says. And that's what would have applied ourselves as this committee. So I do want to say that, having listened to you, we share the issues that you have raised, but I do want to rule as the chair that we will proceed with you, with Advocate Bauer, and indeed, if there's a further need from your side to further seek legal advice, we cannot bar you from doing that. So that is certainly my ruling, honorable members, in relation to what has just been placed on us. Any member who's uncomfortable with that ruling? Honorable Ngola and Honorable Milam.
No, Chair, I just wanted to say that's in order. We actually support that ruling. Thank you.
Thank you, Honorable Ngola. Honorable Milam.
Thank you, Chairperson. I also support the ruling. I just wanted to get clarity. The Which particular section of the PP Act is Mr. Mataboge referring to?
Thank you. He would have read it and quoted, but that can be repeated. So I'm going to ask Mr. Ibrahim later to just repeat that, or Mr. Mataboge himself to do that, but he did take us through that. Any other member?
From the virtual, Honorable Suele, my hand is up.
Yes, Honorable Suele.
Chairperson, I support your ruling because that has been the decision of the committee. So I'm supporting your ruling. And what you explained is what transpired before us. Thank you.
All right. Thank you, Honorable Suele. There is no other member on this, but I do see a hand of Advocate Mpofu, and I will give him the opportunity.
Yeah, thank you, Chair. Sorry, I won't waste your time. I'll be brief again. Just to place on record, one, that there was no invitation for us to comment yesterday specifically, and I'm sure that the YouTube evidence will show that. You just closed the meeting after the report back. And then the other issue is the last input that this was a decision of the committee is not also entirely accurate. I think it was a proposal, maybe, or decision of the legal representatives or the secretariat, who said that we should, the media and the public protector and the evidence leaders should be excluded. Now, obviously, the committee embraced that decision or endorsed it because it did not call us back. So the third issue is that what we're talking about, Chair, is that this is a chain reaction. Our exclusion is what led you to have to report back to us and then display the message. If we had not been excluded, we would have all seen the message and decided at that point whether it should then be made public, which is what Mr. Mataboge is complaining about. But that's water under the bridge now. The last point is that I think what Mr. Mataboge is raising concerns some of the issues we were discussing on Monday about the rights of witnesses as well. Of course, we have to assert our rights and the rights of the public protector and the integrity of the process. But at all times, we must also watch out for the rights of the witnesses, just as because they are citizens of South Africa. And maybe the last point is that these deliberations are part of the work of Parliament, which by definition should happen in public, unless if there are compelling reasons why that should not be so. Thank you, Chairperson.
Thank you very much, Advocate Mpofu. I certainly note your discomfort on those issues and your comments. I wouldn't want us to get into a debate about the issue I'm raising about when I said I opened the platform for people to come in, and that the issue now becomes whether I specifically would have called PP or not. I wouldn't want us to go into that, but I note your areas of discomfort that you have placed on record. I do still make the point that the ruling I've just made will stand, and we will therefore henceforth continue from now. The time now is 10:29. I certainly will add that 30 minutes to Advocate Bauer, who would have finished by 1 o'clock. So there's 30 minutes taken out of her time. I now want to invite her to take the platform.
Good morning, Mr. Mataboge.
Good morning, Advocate Bauer, and can I switch off the camera if allowed, Chair.
Yes, you can do that, Mr. Mataboge.
Thank you very much, Chair.
Mr. Mataboge, as you would have heard, I'm placed under some time constraints. So I'm going to try and go through things very quickly. But if there's any issue you think I'm going too fast, please let me know. We left off on Monday with certain information that you would come back to the committee on. And I don't know if you have that information already. And whether you want to kick off for that or whether I should, well, actually, let me do this. I will continue and we'll get back to the questions that we had left with you. Would that work?
It will work, Edward Bauer. It will be fine.
Okay. So we had essentially, I think, left off with a complaint that had come in on the 8th of November in relation to the breach of the Executive Ethics Code by Minister Gordhan, as alleged, and then the complainant had lodged on the same day a second complaint in respect of the SARS unit, right? I want to take you to an email which you then received on the same day from the Public Protector, which will go to page 5978. On the top, right? And it's headed subject under some information for investigation, BB&D, and it's dated the 8th of November. Do you see that, Mr. Mataboge?
Yes, I do, Edward Bauer.
Right. And I don't want to go through the entire email, but I want to pick it up at the top of page 5979. Shippo, can you go there? At the top of page 579. Do you recall this email, Mr. Mataboge?
Yes, I do, Edward Bauer.
So if we take you through it, South Africans must remember that it was under the watch of Coleman, Andrews and Bain and Company that books were cooked whilst SAA fleets were sold under the disguise of turning the airline around. And then it says, Pravin Gordhan, like any other South African who is accused of corruption, must face his day in court on the 8th of November to explain. Do you know what court proceedings was being referred to on the 8th of November?
No, I wouldn't know. Even if I knew, I wouldn't remember.
Then there is a series of questions posed. Why was Tatus Customs IP, which is now called Interfront, owned by SARS, bought by Pravin Gordhan and Trevor Manuel for 72 billion rand, and it was actually worth 2 million? Why did SARS buy an IT company, Tatus Custom IP, for 72 billion, yet still spent 8 billion on IT costs? Why was the 1.4 billion IT tender that went to Baron, Budge and Dominic BB&D never advertised? Why was BB&D contract extended over a period of 12 years without any tender processes being followed, but having relied on Barry Hall's personal experience and memos for the project? Why was Oracle removed at SARS and replaced with Accenture and BB&D when there was no proof that Oracle was underperforming, and when the serious conflict of interest as Barry Hall, who is the former Chief Operations Officer of SARS, was headhunted by Mr. Pravin and also a shareholder of BBD? Why were 15 officers of SAPS and Scorpions illegally bugged by road unit members? If SAPS and Scorpion officers were not bugged, how did Gerinal and road unit members obtain evidence to nail Jackie Salebi? Were weekly recordings of the illegal bugging downloaded and given to Pravin Gordhan, Ivan Pillay and Gerinal by road unit members who were paid 1.2 million by Gerinal? If two former rogue unit members have turned state witnesses and Pillay, Lachrenberg and Andries van Rensburg are now criminally charged, why not allow this process to be tested by an impartial court of law and not a commission in which Pravin had been able to brief Judge Nugget? I think it's probably meant Nugent. The total disregard for PFMA and preferential procurement by Pravin Gordhan also permeates at SAA and its subsidiaries, to which Pravin has seconded his lieutenants like Bain & Company, to ensure that the national carrier is collapsed in order to legally give it to private individuals like his nephew Ketso Gordhan, who enjoys the luxury of being one of the few black-owned companies which procure with SA in a space where 98% of procurement is still enjoyed by white companies. If such a state of affairs is left unattended, South Africa is bound to turn into a mafioso state where corporations collude with politicians to undermine the rule of law in order to maximize profits. Pravin Gordhan is a threat.
I'm not hearing you on my side.
Sorry, are you hearing me now?
Yes, but it's unstable. You keep breaking up.
Okay, let's see if it goes better, if we can get the IT people to hear. I'm reading I'm reading the email and you're following with me. I'm at the last paragraph. If such a state of affairs is left unattended, South Africa is bound to turn into a mafioso state where corporations collude with politicians to undermine the rule of law in order to maximize profits. Pravin Gordhan is a threat to democracy and must be stopped before he causes more harm under the disguise of cleaning up. You received this email from the Public Protector on the 8th of November, correct?
Correct, Baba.
Did you understand by Pravin Gordhan is a threat to democracy and must be stopped? Must be stopped in which way?
I wouldn't comment on that, but I wouldn't comment on that as an investigator. But what I could say is that some of the companies like BBND and others that are mentioned here, they were already part of the investigation by the office. So if an email like this one came through, it was just for a noting or attention from the PP, and not necessarily for us to act on it.
Right. So if we go back up to the numbers that I read out, a number of what is fairly put as questions arise from the complaints that had come into your office on the 8th of November. Would that be correct? Just
not from the complaints, because some of the complaints, like I say about the BBND complaint, is the 2016 matter that had started within the office. So it would not have been a new file at the time, as well as which other one? Let me check. The one that relates to Oracle as well was part of the 2017 IMS investigation. So we would not have necessarily been for new files or for new matters to be attended to by us as investigators. It was for noting, if I may say.
That is so. So some of the arises from the SAA complaint, which we covered yesterday, had already been closed, and at least as at this point, the number 3, the Baron Budget Dominic, was still pending or had not yet commenced with investigation. Am I correct?
You're correct,
Except that you did not cover it yesterday. It was the day before.
My apologies if I say yesterday, I lost a day in this.
Unless the two of you were doing it.
Thank you. Now, you also, yes, I'm going to have to remember this. You also on Monday, Shepa, you can take it off.
Tuesday.
Yes. Thank you, Mr. Mataboge. Tuesday.
Right. So when last we got together on Tuesday,
yes.
You had shared with us that you had not had insight into the closing report that had been prepared by Mr. Madiba.
Yes.
And I want to take you to page 6546, bundle F, and it would be in 190.2, 190.3. Just hold on a sec, let me just be sure. 6550, yes. Yep. Right. Now, I had asked you a question, and maybe this was one of the questions that we had remained outstanding. Is whether you had had a meeting with a whistleblower at any stage, Mr. Mataboge?
No,
I'm not
Advocate
interested, not interested in the identity of the person. I just want to be clear about it.
No, not at all. There were emails that were sent to the investigation team, but to which the team responded, but we never had a meeting with the whistleblower that has sent the emails.
So, Mr. Mataboge, you would have had an opportunity to look at it. And the reason why I'm asking you this is because the whistleblower didn't refuse to meet with the Public Protector's Office. The whistleblower said, I would be available in December to do so. And I'm asking the question that, having indicated that the whistleblower would be available in December to meet with the Public Protector, why an appointment was not scheduled with the whistleblower to meet?
Unless I was to be shown the undertaking by the whistleblower to us on his her preparedness to meet with us, I will not be able to answer, because in December we met the other complainant to the matter, who was the one who wanted to meet with us, but not the whistleblower as is referred now by Advocate Bauer. So unless I'm being shown.
Sorry, Mr. Mataboge. I want to interrupt you. I'm going to ask Shepard to put this email up. It's included in the 189 bundle, and I couldn't find it, so I've taken it out separately just so that I can show it to you on the screen. The one I sent you this morning, the number 5. All right, to do that. So I want to go down to the bottom to the email that's responding for. No, go up to the email Ms. Vuyani sends. So this is on the October the 19th after the complaint.
Sorry, Advocate Bauer, can you have the reference again? Sorry.
Mr. Advocate Mpofu, it's in bundle 189.
189.
Sorry, it's bundle F. 189, and you will see in 189 there's a whole lot of sub number of documents, and I've lost the exact sub number, Advocate Mpofu, because it was going to be one of the questions I asked Ms. Vuyana, and having now switched gears, I've lost some of my referencing.
Okay, all right, fine. We can get it later. We'll use the screen for now. Thank you, Chair.
Yeah, sure. Right.
Thank you.
It's the letter, and I actually think it could be part of the investigative diary number 71 as well, but I stand corrected. It's the email that Ms. Mvuyana sends off on the 19th of October after the complaint comes in, and it says, kindly be informed that the Public Protector has received your complaint. It's been allocated to good governance and I'm assigned. You are requested to attend a meeting with the investigation team by no later than Friday the 26th of October to formulate the issues and get a better understanding of the allegations. That's a pretty standard letter that you send out to complainants, isn't that so?
That is correct, Ruba.
Right. Now let's look at the response from the complainant. It says, Dear Advocate Vuyana, thank you for your response. I'm not residing in South Africa. I will only be in the country in December again. Could we schedule an appointment for then? And so the question is, did you meet with the whistleblower? And if not, why was an appointment not scheduled?
We didn't meet with the whistleblower now, I remember, because Advocate Vuyana will be able to talk to that when she appears. But she said she made all attempts to contact the whistleblower up until that she lost hope. And I will not talk further to that. I think she'll be able to answer, because even if you look at the email, as much as I'm the supervisor, I was not copied, but she briefed me on that. That's why now I was remembering meeting the other complainant to the matter in December, not the scared whistleblower.
Right. Okay, so that's I just wanted to check if to do that. Right. Now, if we go to the document 54 at page 190.1. Right? You said you didn't have regard to the closing report, but you did receive a copy of the closing report. Isn't that so?
I wouldn't have received it. Maybe I would be honest as an investigator. Like I said the previous time, even when we consulted, I've never had it, and for reason that I advanced, I didn't want to have sight of it, so as to proceed with the other investigation, free from influence of any other that was contained in that report. And I still stick by that because I never saw it at Power. The team may have seen it. That wouldn't be appearing. She will talk to that, I believe.
I want to take you through a series of emails as soon as, right. On the 12th of April, go down to the bottom. We have, oh, I think you must go down a little bit further. Let's just get no, okay, it's fine, sorry, stay there. There is a request that goes around to the office in a precursor email asking about this investigation that had been completed. And then the late Mr. Madiba answers and he says, yes, it was under my stewardship that the investigation had been completed. And he says, attached here to is a copy of the closing report on same. And he tells you what it was being closed and he gives you a snapshot of it. And you are included in this email chain of the 12th of April, Mr. Mataboge?
Yes, Edward Bauer, I'm included, but like I said, with my conscious decision, I did not look at the report. It doesn't mean that the moment I got into my mail, I would have opened it and read it.
So let's go up to the top. It says, dear CEO, it then goes to Ms. Paloy, find the response in the response to your question. And Ms. Mutsetsi says, thank you. And then let's go up. All right. The report is then also provided to the public protector, Mr. Kabinda, and the chief of staff by the CEO. You see that? And then if we go, right. If we go to 6551, it might be in bundle 190.3. Okay. Right. Go up. I suppose start from the bottom. 14th of May at 17. Okay. There is a request from the public protector for a copy of the draft Rule 79 report, and you tell her that you're not quite ready for it. And you're going to give her a rough draft, and you are going to ask for your waiter guidance, but you're proceeding to draft. Would that be correct?
That is correct.
So let's go up. He then says, she then returns and she says, find attached with my comments at 5 o'clock the afternoon. I'm trying to get proof of the payments to suppliers and to staff. It is there in the closed file by Madiba. Did you get hold of Besoski? Can we do a Skype interview and Piecha?
Sorry, it is not there.
Come again, Advocate Mpofu.
I'm sorry, Chairperson. Yeah, the part in brackets, Advocate Bauer read,
okay.
It is there. It actually says it is not there.
It says, is it not there? We're both wrong, Advocate.
Oh, yes, yeah. Is it
not there? It's a question of.
Okay, okay, that's sorted between the two of you. Proceed.
Thank you. Thank you, Chair.
Go up on the email. Right. Thanks, madam. Not yet. We have been trying to get Piecha's number without success, but we didn't try Beskoski, which we will do today. We will check again in the other arch lever file of proof of payments to the suppliers, and then go up. And the public protector says, Rodney, I perused the 2012 complaint, and there's all the evidence of recruitments and payments and contracts of the people who worked for Rogue Unit. Include them in the notice. All this happened when PG was the AO. We'll send the file back and Mbuyana should use this information. Do you see that, Mr. Mataboge?
Yes, I'm looking at it, Ribawa.
So you still don't go to the closed report?
Yes, because here PP is referring to the evidence. I still don't, because the closed report is a narrative. And if as an investigator, you want to do your own narrative, that is my personal view. You don't want it to influence how you write and how the other report is being argued, which I also shared with Ribawa when we talked about Friday 2 report that I was part of Friday 2 investigation. Thank you.
So you do go back and you look at the evidence in the 2012 file. Just don't look at the closing report.
Yes, because the evidence file is an act lever file, and it's not even looked at me alone, it's by the investigator herself, but it doesn't have the closing report. The closing report normally gets to be filed with registry, and it's a separate folder from the evidence file.
So you effectively re-look at the evidence that was before Mr. Madiba. Would that be a fair way to put it?
I think the one that the PP specifically directs relating to recruitment and payments, that would have been then the one that the team would have focused on.
Okay. Just go up. No, actually not okay, Mr. Mataboge. Let me be clear about this. You have all these documents which underlies an investigation that had previously been done by the public protector. I'm asking you whether you considered all that evidence that was before Mr. Madiba, or whether you only selectively looked at the evidence.
We wouldn't have considered all of it if that's what you're asking at with power, because the matter that was before us related to a particular complaint.
Well, how would you know that if you didn't look at all the evidence?
The focus would have been on like the PP's email is saying, on the payments and the HR record that would have been there. We would not have had to look at everything. But like I said, I supervised the investigation. The team that dealt with it would have looked at what was viewed as important for the purposes of the report that we were drafting.
The PP says there's also proof of payments to these people, so we can mention that because we got from SARS. I'll bring some more evidence checking the disk and we'll share tomorrow. So if I take you to paragraph 5.4.23, now we have to go to bundle E, Sheppel, bundle E, item 7, item 9, no, item 4, started at page 216 where the report begins. Yeah. And we will need to be on paragraph 5.2. 5.4.23. Oh, so many questions. 5.4.23. It's page 296.
Yeah, there's a bit of an echo. It's also here. So IT will just try and improve that. No, it was an echo when he spoke now, she spoke now. It can be from both of them. There's certainly, Mr. Mataboge, if you have got any TV on, you can switch it off there or any other thing.
It's aircon, Chair. Let me switch off aircon. It's aircon.
Oh, okay. Hopefully you might have to switch it on again because it might be hot. But try and do that. Thank you, Mr. Mataboge. Advocate Bauer.
Thank you, Chair.
I'm referring you to paragraph 5.4.23 of the investigation, which says it is indeed correct that the issue relating to the recruitment of staff for the intelligence unit had been previously investigated by my office. The matter was finalized and signed off by a chief investigator, which means that I'm able to review such report if the need arises. Do we understand that the aspect of the SARS unit report which deals with recruitment is effectively a review of what had previously been investigated by Mr. Madiba?
Although I'll try to answer with Bawa, but I think here the PP will be able to answer. But the long and short of it is that as a process, Mr. Madiba, once he signs off a matter as a chief investigator, his report can be reviewed internally by the executive manager to whom he reports, as well as the PP once the PP or there's a dissatisfaction with regard to that report. So that is why this comment, because he at his level had signed the closing report.
I have no difficulty with the principle, Mr. Mataboge. I think we established that yesterday already. The question I'm asking as chief investigator in this report, when you were doing this investigation, did you consider it to be a review of the work that Mr. Madiba had previously done?
No, not at all. That's why I was saying this matters in our view. That's why I didn't want to look into that report. We were not similar, we're not related.
Now, as I understand your view in respect of Vrede 1 and Vrede 2, you similarly indicated to us that you did not have regard to the Vrede 1 report because you didn't want to have your view tainted.
Yeah, not necessarily tainted, but influenced by the narrative that would come from Vrede 1, because I wanted to present my own narrative based on what would have been before me. That is correct.
Right. And the evidence which served before the Vrede 1 team, what was your position in respect of that?
When we dealt with Vrede 2, we had to write anew, afresh to the people that were affected, because now the complaint we're pursuing now related to the involvement of the politicians, not the administrators who would have been the DG and others. So we were basing our engagement on Vrede 2 on the letters that we had sent to the respective members of the Free State provincial office, including the Premier in the Free State. So it was based on the record that we had received as a new investigation, not on the basis of the previous Vrede 1 evidence or records.
Mr. Mataboge, it was simply a question to ask you, did you have regard to any of the evidence which had served before? I understand that you did it on the basis of the material that you had gotten pursuant to your investigation. I'm trying to test, Mr. Mataboge, what did you look at that was also before the Vrede 1 report, and there were differences in the investigation. So now let me take you, it's 190.2, Shepo, it's page 6424. In fact, it is an instruction from the public protector that you must have a look at you must get the evidence used in the Vrede report issued in 2017, and that Mr. Satauli Muntu must assist you in getting the Rule 53 record.
Yeah, just wait for us so that we can all get it. Slow taper. Page number.
6424. Right. It would be, go down. There we go. It's the 6th of July. This has got to do with the section 7.9 of the Vrede 2 report. Do you see that, Mr. Mataboge?
I'm looking at it, Riva.
So the PP sends off an instruction that says the meeting must take place for the entire investigation team and evidence. Mr. Mataboge, because I have time constraints, I'm cutting through stuff. If you think I'm misrepresenting anything on the email, jump in, and I'm sure Advocate Mpofu will do the same. But there's an instruction from the PP that you must get the evidence used for the Vrede report issued in 2017, Muntu to assist with the Rule 53. And I assume that's the record. Goes further and says the Gupta leak copies were delivered by outer to the office and were sent to GGI. Then Advocate Fourie let them assist with copies were never used because their authenticity could not be verified by discussion with Advocate Fourie on other information contained in the leaks which GGI was investigating. Do you recall this, Mr. Mataboge?
Yes, I do, Riva.
Did you get the evidence from the 2017 report and the Rule 53 record from Muntu?
I don't remember. I don't remember because I'll ask Ms. Mviana to help me here because I still even I remember saying to the then COO to say I don't want to have sight of these records because I don't want it to influence the investigation and the outcome of Vrede 2 report.
The next thing says ICE to assist with email communication on the Vrede matter with Free State Office on the Gupta leaks. Would that be a reference to ICE Magashule?
I'm not sure, or is acting CEO, I'm not sure what it stands for.
It's acting,
Could be
acting chief executive.
That was very quick. Thank you, Advocate.
I know that's because I asked the same question a few days ago.
Thank you, Advocate Boff. Advocate Bauer.
Chief, we used to have ACEO, and now we're down to AC. Okay. We cannot finalize this report without referring to the touchstone of the previous report for synergy. This will also assist to refer to the Accountant General finding, which was brought to attention of the Premier, which now DA says there should be a finding of violating PRECA, the recent issue creeping. And then there's further things that she tells you to get. So there's a clear instruction that you must look at the evidence that arose from the previous investigation. Do you see
yes,
that?
Alfred Bauer, I see that, and I'm going to then become a bit sound like insubordinate. But if one were to look for purposes of the committee or making one's own mind, the Vrede 1 report and the Vrede 2 report side by side and see any synergy or any similarities there. I would be interested to be shown that, because I and the team and the COO kept on desisting from looking and synergizing as the word says.
Mr. Mataboge, let me tell you at the outset, and I'm hoping I'm going to have enough time to come there. In my view, in reading both reports, the second report is a much more superior, well thought out report. There are issues that I'd like to raise with you to the extent it impacts on the first report. So there is certainly a much better investigation conducted the second time round. but I'm hoping to get to that. What I'm trying to work out is relates to evidence and process for the moment, right?
Chairperson,
Advocate Mpofu, just pause, Advocate Bauer.
yeah. I object to that evidence from Advocate Bauer. She's not here to tell us which report.
I
is-
withdraw it, Advocate Mpofu.
No. Thank you. But Chairperson, really, I don't want to have to do this again. The Constitutional Court made it clear that the legal representative of the public protector is not here to give evidence, but to elicit from the public protector evidence. That applies equally to the evidence leaders. If she wants to give evidence, she must just be sworn in by Ms. Ibrahim, like everyone else.
Yeah.
Thank you, Advocate Mpofu. Before there's an echo that says, yeah. I think she has immediately withdrawn, Advocate Mpofu. Thank you.
I appreciate that, Chair. Yeah, I was just preventing me having to jump up and down, as she said earlier.
Okay, thank you.
Right, so let me move on to something. I'm going to come back to the Freire report because I want to do a different kind of exercise. Let's just finish this. We were told by Advocate Mpofu when he was cross-examining one of the witnesses about the 3-strike rule, and I think the 3-strike rule within the Public Protector's Office, as I understand it, is that proposition was put that you don't simply issue a subpoena without asking someone to come first. That is unfair, and the Public Protector said it might even be as far as to say illegal. So I'm going to ask you the question on the back of that submission having been put before the committee by the Public Protector, what steps was taken to get Mr. van Lochenberg to come to the Public Protector's office before a subpoena was prepared and signed by the Public Protector?
The 3-strike rule is a process of investigation wherein we write a letter and we send a reminder, and we then send the final reminder to say if there's no response to the second reminder, the people will invoke a powers of subpoena. That is a separate process. But it's unfortunate that when we issue subpoenas, they are being understood to be hard and harsh or to other people. But the PP has said, or even the institution, we don't use subpoenas only as part of the bringing people or responding to the or complying with the 3-strike. If we want the matter to be finalized quicker, like the EMEA matters, the quicker way of doing it is a subpoena, and that subpoena doesn't mean for a person must appear. We request that the person must submit an affidavit as well as supporting documents so that it may help us fast track investigation, not necessarily to try and push and antagonize the respondent. It's a matter of trying to be expedient in the investigation process. So if I come back I want to come back to your question, the subpoena that was issued to Mr. van Lochenberg, it was not only him, it was a few senior officials of SARS that were also subpoenaed under the same date, under the same subpoena to respond to the PP by submission of affidavit and supporting documents.
Mr. Mataboge, you didn't answer the question. The question was, what steps was taken prior to a subpoena being issued to obtain Mr. Lochenberg coming?
There were no steps because he was not a respondent in the context of the complaint like SARS was a respondent. He was an affected party. So we wanted to, by issuing the subpoena, we wanted to offer him a choice. So the process of 3-strike would apply to the actual respondent, not the affected party.
I'm not sure I understand that. What choice do you offer him by issuing him a subpoena off the bat without giving him a choice to come. So, because I'm trying to compare what is being done in the Vrede matter when we're dealing with people in the Free State versus and the explanations given there versus what's done in the Gordhan matter. So maybe you could explain to me what choice was provided when you issue a subpoena from inception.
Even the people in the Vrede investigation, they were subpoenaed without having been written letters to, because they were affected parties. The MECs and then all those people, they were subpoenaed as a matter of experience.
Right. So when we do it as a matter of expedience, it's not unlawful. Because the proposition was Mr. Samuel, that because if several letters were not written first before Mr. Magashule was going to be summoned, then that process would be unlawful. And so I'm checking with you whether the criteria is one of expediency that informs unlawfulness.
I would not want to comment on the unlawfulness, but it's part of the process. If one were to refer to the PP Act, the PP, they decide on the process, at her discretion that needs to be followed in an investigation. But that doesn't mean it has to be unlawful. If I may answer you on that.
Right. So if I just on the scheduling of reports, because this becomes important. You get told ahead of time or at the stage, let's talk about 2019, when there's going to be media press briefings and when reports are to come out, the CEO would inform you and there would be like a date. In fact, you were told that the PP was desirous to have the SARS Pillay report issued by the 30th of April. Do you recall that?
Yes, I do.
It was ultimately issued on the 24th of May, correct? Mr. Mataboge, it doesn't matter.
I'm here. I'm trying to check whether the date is correct.
Right. Just assume for purposes of now that I'm correct, that it's the 24th of May, that the pension Pillay case was issued and that the SARS unit report was issued in the first week of July, I think the 4th or 5th of July. If I'm wrong, somebody will correct me. But just for purposes of this, so that we don't get bogged down in dates, Mr. Mataboge, I don't expect you to remember the actual dates of it all.
I think, if I may say, you confused me when you talked of May, because I thought we were dealing with the rogue unit report, or the so-called rogue unit report, which was in July. I know exactly. I know as well that the PA one was in May. So I thought the date that you are referring to now is incorrect for the rogue unit report.
No. Sorry, I don't want to confuse you. I'm trying to establish that the pension Pillay report comes out on the 24th of May, and that precedes the SARS unit report that comes out in July.
Correct.
Right. Now, if I then take you to page 5897, right, you raised the issue yesterday that, in fact, there's a chain of command: investigator, chief investigator, executive manager, COO, and PP, and that in respect of Kusasa, you reported directly to the PP, but that in respect of the SARS unit report, the EMs had to sign off on the submissions. It was then forwarded to the CEO and then to the PP. Do you recall that?
Yes, I recall that.
And I'll tell you upfront, Mr. Mataboge, I do not find an indication of the EMs being involved, signing off on the 7/9s or the actual reports. So let me take you through the documents I do have.
May I comment to that?
Sure.
You wouldn't find them, because when we submit the 7/9s and the documents that need to have approval of the PP, the EM signs on the memos, which are internal memos. They are not for outside. So if needed, I'll search for the memos that processed all of these investigations and have them availed to the committee, because there's no way that when I submit, for instance, for SARS matters, I would have submitted them direct to PP, for instance, the draft 79 and the draft report, because it has to be reviewed and quality assured by my executive manager, who then reports to the CEO, who then has also to review it. And I'm sure those memos are there.
Right, so we'll add that to the list of what you would need to provide. I am going to say to you that my juniors, my co-evidence leader will find the reference in Ms. Mokhaladi's affidavit and I'll read it to you, but that's before the committee. I'm saying to you from the documents we have, you are being submitting these 7 9s directly to the PP, and in almost all instances, neither the EM nor the CEO is even included in the email chain. And I'm first wanting to take you in that regard to 5897. Right. And we go down to the bottom, and it starts off, Mr. Mataboge, where you are asked by the COO to attend a meeting relating to the Free State website. Go down. And that was one of the reports you were charged with, correct?
Correct, yes.
Right. And you asked to be excused from the meeting because you've got 3 deadlines, 279 Bosasa and the Rogue Unit, as well as the final report on Pillai's appointment, all of which the PP wants tomorrow.
Correct.
Right. And they telling you, you need to come to a meeting and your apology is not accepted. Right. Now, would
Yes.
the COO and the EMs not have known that your 7 9s and the Rogue Unit and Busasa's stuff would have been due, because they would have had to sign off on the Rogue Unit and the Pillai's appointments before it went to the PP?
I wouldn't know, but like I said, to cut a long story short, the memos that related to SARS unit investigation, I have them all. I'll submit them except for Bosasa. So I wouldn't be able to answer as to why they would not know.
Okay, go up. You then go to the CEO and you say, may I humbly see you, if possible, for advice on the situation I'm facing regarding directions and duties in my sphere of work. The trail of emails below is an example of a dilemma I'm often faced with. And what is that dilemma that you were referring to, Mr. Mataboge?
Come again? Is the pause here with Advocate Bauer, or are you still here? You muted, Mr. Mataboge? Mr. Mataboge, you are muted. Are you still with us? Yeah, there he is. Just unmute. We just lost you a bit. Talk to us. You are muted. You are muted.
He's trying to call Temmingus or someone.
You are muted, Mr. Mataboge.
It's the generators again, Chair.
Okay, we're told that he's indicated he has got a small issue with the mic, so IT is going there to assist. With that, colleagues, what we're going to do, we're going to take a 10-minute tea break, and we'll be back at past as Mr. Mataboge is fixing that. We pause for 10 minutes. Thank you. Okay, I don't see him. He was here just now. Where's Kombalo? Hey.
I-generator ziyafa ba.
IT is trying to assist. Okay, so we have, it's just been confirmed it's IT, not generator. So just to be on record.
If we can just put the email back on the screen, and I asked the question, the trail of emails is an example of the dilemma I'm often faced with. And so I asked you to articulate what that dilemma is that you're faced with.
Yes, that's what I did, Argo. I said we getting instruction or directives from the PP, especially on Bosasa, and the CEO would want me to do something else, and like the email reads at the bottom, would not take my trying to apologize to be excused from the meeting. So that was that's why I'm using a word being between a rock and a hard place there.
Now, indeed, you have two reporting lines. One to your meeting.
I wouldn't want to say so.
Okay, that's good on your side. There was just an echo here with Advocate Bauer, so maybe IT can just assist us here. It was not with Mr. Mataboge. Try again, Advocate Bauer.
So, Mr. Mataboge, I didn't finish the sentence. I was saying to you that on certain instances, you end up with two reporting lines in respect of certain applications to your EM and your CEO, and in respect of others to directly to the public protector. Would that be?
That's why I made my response. I said I wouldn't necessarily say so, because it was only in respect of SASSA that this thing was happening.
All right. So if we go up on the email. I think you must go up, further up. Oh, sorry. Let me go back to that email. Sorry.
But doesn't understand up and down. So,
yeah.
So you need to just clarify that properly.
You then, I don't think you await for the response from the CEO, am I correct? But you then very shortly thereafter send an email to the PP directly, and you say, I had intended to ask for CEO's advice this morning. I take it CEO and ACO is the same.
No, ACO would be an acting, CEO would be the CEO.
Oh, so there's.
But not at the same time. I'm trying to just
Yes.
unpack the abbreviations for you, Advocate Bauer.
So I had intended to ask for CEO's advice this morning per email. The situation that is developing with me is really concerning to me, as I'm now becoming unpopular with my supervisors, managers, and that unpopularity stems from not effectively your plate is full, Mr. Mataboge. Would that be fair?
Yes, it would be full, yes.
The PP then responds and says, Rodney, attend the COO meeting. I will get the 3 tasks as soon as you are done. Send me the drafts of the report of Pillay, your section 79. CEO, can you make sure that COO and EM give support to Mataboge? I will engage with any staff as and when I want them, must not subject them to such. So pursuant to that, you were asked to submit the drafts of your reports of Pillay and your section 79 directly to the public protector. Isn't that so?
Yes, that was what was in the email below. It was just a continuation of what the PP had directed.
These reports at that stage, Mr. Mataboge, was these presentations to think tank or task force or I don't know what they called anymore, where you would go and present your report to a committee that would then provide input on it. Was that in existence already?
What was in existence here, if I recall, was the quality assurance structure that had Mr. Matavela as the quality assurance person.
So you're the only person who would look over your report for purposes of quality assurance would be Mr. Matabela.
But after they had gone through the EMs and the COO, we would go to quality assurance before it goes to the PP, unless advised otherwise.
Okay. So you wouldn't do a presentation to the EMs and the CIO of your report, as I understand from Mr. Lamula's evidence, was the case at some point when he was at the office?
No worry about. I said only in respect of SASA. All other matters, the delay and all, I would have presented them through the normal channels.
Okay. So are you saying?
Except when then there was a need for an agent, maybe media briefing coming in, the PP wanted to have sight of the report. But like I said, I would still look for the memos that would prove to the effect that the delay and the SARS unit thing 79 and the draft reports went through the normal channels, except for Bosasa.
Right. So
and
you
even in respect, sorry, even in respect of Bosasa, it didn't happen from the beginning. At the start, the normal channel was being followed. Only when we were going towards the 7-9 and other things, then that reporting line had to start. And I wouldn't comment on that. I think the people would be the right person to talk to that.
Fine. Yeah, I am going to. I think in fairness, I must put to you what Ms. Moghaladi had said on her affidavit to the committee. And if we go to Ms. Moghaladi's affidavit at bundle D, item 21, in the SARS matter at 137. And if I'm just going to read it to you quickly. It's 137 and 138. In relation to the SARS unit investigation, I met with the complainant on 8 December 2018. The investigators who were responsible for conducting that investigation were Mr. Rodney Mataboge, who was the chief investigator, and Ms. Bianca Mvuyana. To the best of my recollection, I had scant involvement in the investigation. I was at the time acting as the EMGGI. When I started acting in that capacity on 1 November 2018, I found the investigation of allegations of maladministration and impropriety of SARS already underway. I was not involved in that investigation, and as it progressed, the investigators did not report to me about it. I understood that Mr. Mataboge and Ms. Mbuyane reported directly to the PP regarding its progress. As from 1 June 2019, Mr. Mataboge and his team, which included Ms. Mbuyana, reported to Ms. Motsetsi, not to me. Do you have a comment on that?
Yes, I do, Edward Bauer. I need to refer to the memos because, like I said earlier on, it's only in respect of Bosasa that I recall not going through the normal EM and COO approval lines on the memos. So I'll have to search for the memos that pertain to who was my EM, because I had several EMs during the period that is alluded to here. But I'll have to check the memos. I don't recall Ms. Moghaladi just attending the meeting and that was the end of it, because the memos had to go through the COO to the PP. And first with the EM anyway.
Can I take you to page 6548? I think it's also 109.2. So 6548, go down. Yeah. You say, dear PP, kindly receive the most recent draft with proposed remedial action, yellow text for guidance and correction as we continue to try and finalize the draft. I continue to quality assure the draft as well, madam. The challenge is still with incorporation of the 3 responses to the 7 9s. Those are the responses from Messieurs Magashulu, Palay, and Gordon, correct?
Yes, I do.
Right. So you submit a draft to the PP, just go up. on the 1st of July, right? In respect of the SARS unit matter.
Yes.
And then we go up. She then says to you, noted, and the communication is solely between you and her. The Pusasa one also want draft by Thursday and we can discuss it then. Right? That's her instruction. Now go up. You tell her I'll do my utmost best to do that. Go up. She then says, Julie, actually, we can discuss PG today. You can indicate the time in the afternoon and the Pusasa Thursday. I get draft to share with SC before finalizing if necessary. Do you know who SC was, Mr. Mataboge?
No, I wouldn't know.
Were you party to any inputs by SC in respect of the Pusasa draft?
Bosasa draft, no, the only input by the SC was when there was legal opinion at the beginning of the investigation. But I wouldn't know if there was no any other involvement of SC beyond that, as far as I'm concerned. Because I've got all the drafts. I've got all the drafts that are many that went through my laptop.
Mr. Mataboge, if an SC provided the PP with input and she forwarded to you, you wouldn't necessarily know whether that input came from her or whether that input came from an SC. Would that not be so?
Yes, that would be so.
You say, thanks, madam, will do. I will check with Mr. Kapinda for a slot after lunch today for PG's draft. I'm also in agreement with PP's view of sharing Pusasa draft with SC. You sure you don't know who SC is, Mr. Mataboge?
I'm sure. I'm quite sure.
But you're in agreement that the draft must be shared with SC?
Yes, because we...
And you're also in agreement to finalize it?
Advocate Bauer, pause. Advocate Mpofu.
Okay, Chair. Well, I've been quiet on this all morning, yeah, but Advocate Bauer is now busy cross-examining the witness. Just to say that that is not what she is supposed to do. And if she's not cross-examining, then she must accept the answers from the witness and not second guess them and interrogate them and basically cross-examine the witness, unless if she has any other instruction from someone, I don't know where. So if the witness says she doesn't know, he doesn't know who SC is, she say, is he sure? And then as if there's another evidence coming from somewhere pointing to the contrary. And if there is, we must be please informed about it. Thank you.
Thank you, Advocate Mpofu. Advocate Bauer.
Chair, can we get a ruling on this? Because we have repeatedly had Advocate Mpofu say, I'm not allowed to cross-examine the witness. And I have repeatedly responded that saying in terms of the directives before this committee, I'm entitled to ask the witness any question.
Yeah. Yeah.
I'm not a cross-examiner. I'm going to the truth of it. I showed him two different sentences. The wording was different. In the second one, he was agreeing that something should go to SC. Now, I want to know that if you're agreeing that something you're working on must go to SC, then logic dictates you must know who SC is.
No, that I don't know whose logic that is.
I asked him to
Sorry,
clarify.
can I come back?
But Chair, before Advocate Mpofu interrupts me and we have an exchange, I want that ruling because it's been carrying on for months of where I keep on getting told I'm cross-examining and I keep on responding to say under the directives I can ask any question.
Yeah, but you can't have a ruling having just addressed only yourself. I want to address exactly that point. Please, Chair.
Chair, it looks like
just pause, Honorable Mwala. Go ahead, Advocate Mpofu.
Thank you, Chair. No, Chair, yes, I think it's fair what Advocate Bauer is raising, because this might come up many times. So if there's a ruling, it will probably curtail more interjections. Now, the point I'm making, Chair, is very simple. I don't know if Advocate Bowen appreciates the difference between asking questions and cross-examination. If she does not, then she must go and read the directive. The directive is very clear that the public protector is entitled to cross-examine. Those words are not coming from the air. And it doesn't have a similar provision for, or the same provision for the evidence leaders. And that must have been deliberate. Now, this thing is simple, Chair. It's a matter of fact. The question is whether or not what Advocate Bauer is doing is cross-examination. If it is, then she must desist from doing it. If it is not, then she must tell us what is the difference between what she's doing and cross-examination. Or she must then confess, as it were. She must own up. Sorry, maybe that's a better word. She must own up to the fact that she's cross-examining because she feels that she's entitled to. That's fine. Then the chair, that's where the ruling is needed. So if she's entitled to cross-examine, then the chair can rule that she is. Then we'll do with that ruling whatever we want. But it can't just be this twilight zone where we don't know whether it's cross-examination or putting questions or whatever. I think the time has come for this matter to be once and for all addressed squarely. So I agree with Advocate Bauer on that score to avoid any further interjections. Thank you.
Thank you, Advocate Bofo. Honorable Mola. But before
I'm fine.
Okay, just before I make the roll, Bauer.
Chair, the directives do not allow the PP to ask leading questions. The evidence leader has specifically been allowed to ask any questions, framed very widely in the directives specifically, which means you don't have to qualify it. There's a specific provision that also says the evidence leader can ask leading questions. If the purpose of the evidence leader is to solicit the evidence and the information for this committee, there is no logic in curbing the questions that an evidence leader can ask of any witness. It defeats the purpose. Mr. Advocate Mpofu, right from the start, had tried to pigeonhole it into a cross-examination, but the cross-examination has a different permutation when looked in the context of court proceedings, which is why I'm resisting going there. In the sense of what my task is as an evidence leader, I must ask the questions in order to ensure that the fullest picture gets put before the committee.
Okay, okay. Honorable Heron.
Chair, I mean, I want to take us back to when we adopted the directives. I actually raised in that committee meeting why the public protector had the power to cross-examine, but the evidence leaders did not have that in the directives, and that the evidence leaders could only ask questions. And the committee adopted the directives exactly as they are, which allows the public protector to cross-examine, but the evidence leader to ask any question, and doesn't include the power of cross-examination. So I think what has to be determined is whether Advocate Power is now cross-examining or asking questions. But Advocate Mpofu is correct that there is a distinction, and the distinction is not, I mean, it is deliberate because we discussed it when we adopted these directives. Thank you.
Thank you, Honorable Heron. I think the ruling I want to make is until the point where Advocate Mpofu came in, I didn't get a sense that we had cross-examination taking place. And I would like us to allow Advocate Bauer to continue asking the questions, which is not cross-examination. Can we proceed in that way? Advocate Bauer?
Chairperson.
Advocate Mpofu?
Yes, I'm sorry, Chair. Okay, Chair, that's if that's your ruling, that's your ruling, yeah. But I can assure you that what is happening is cross-examination. But as I say, that's a matter of, it's a question of fact. It's either you are right or I'm right on that. So we don't have to revisit that. But I do want, maybe just in fairness to the committee, particularly given the background that Honorable Heron has given, which means that this distinction was not just an oversight. It was deliberate, because if it was raised with the committee and the committee decided to adopt the directive as it is, then it was a deliberate distinction. Which brings us back to the question of fact, or what is happening is cross-examination or not. And you've ruled that it is not. I say it is. You are the chair, I'm not the chair. So let's put that aside, yeah. But I just want to say that if indeed the distinction was deliberate, as has been suggested now, then the committee must look into, or maybe not this committee, in the future, the committee now or then must look into amending these directives so that it's very clear that, or whether the evidence leaders have a right to cross-examine. Maybe that's where the problem is. It's not with you or Advocate Bauer or me, but with the directive itself, which makes that distinction and does not grant the power to cross-examine. Maybe, I don't know what our attitude would be if that power was granted. But the whole day and previously we've been having this cross-examination, and I put it to you, and but this, but that, which is vintage cross-examination. Thank you, Chairman.
Thank you, Advocate Mpofu. I note the points you're making. Advocate Bauer, please proceed.
Chair, can we have it put back on the screen, please? Right. Mr. Mataboge, you were referring to a previous occasion with an ST. What were you referring to?
I don't get it. Where am I referring to the previous SC?
In answering your question, I asked you whether you had agreed with the PP's view of sharing Busasa draft with SC. And I asked you if you, and if I let me read the sentence finish, before we finalize it, perhaps even the rogue unit 1, madam. And I asked you whether you had a person in mind, SC, to share these reports with.
I didn't have a person in mind. I was just saying, initially when the Busasa investigation started, the PP through the legal services had sought a legal opinion from an SC. That's what I was referring to, and that then through the Office of Legal Services of Mr. Mustole, we then obtained the legal opinion on that.
And was that legal opinion shared with you, Mr. Mataboge?
Yes, it was.
And do you recall who the SC was that provided that legal opinion?
Yes, would it be because it was from Mr. Sianeho? Yes.
Is Mr. Sianeho an SC?
I'm not sure. I wouldn't know.
Do you know that Mr. Sianeho is an attorney?
I don't.
That's not a voice of Mr. Mataboge.
It's a generator.
No, that the voice that says I don't. I know who that voice is, and I'm asking that voice not to answer for Mr. Mataboge.
We'll suppress the voice. Chair.
Thank you. Please mute. Please mute to protect you.
Okay. Yes. Sure. Can I just wanted to make a point, and I just want to. I want to understand maybe.
On a point of order. Advocate Mpofu, just hold on.
Okay.
Yes, Advocate, Honorable Lagode and Honorable Ngosi.
Okay, good.
Thank you very much, Honorable Chairperson.
Okay. Just hold. I'm told that the witnesses. So there's load shedding there now. They're moving to that.
Load
function.
shedding here with me, I think, but I can still hear, Chair.
Yes, but we just want them to switch on to the generator, the PPSA, which is working.
Oh, well.
Honorable
luck.
Okay.
Chairperson.
Honorable Lagode.
Thank you very much. It's a pity that this load shedding is disturbing the flow of these proceedings. So
Can we pause until the witness is back? Thank you.
Recording stop.
Changing from that to the generator. Honorable Lagode.
thank you very much, Honorable Chair. I just want to say that can Advocate Mpofu allow the flow of these proceedings in this meeting instead of him coming in and out
How?
between Advocate Bauer and the witness? Let's allow the flow of this. He'll get his opportunity to clarify whatever I want to clarify and cross-examine the witness. Thank you.
Thank you, Honorable Lagode. Honorable Ngosi.
So I was going to make the same point that you made a ruling and the ruling was accepted by, in particular, the person that asked, that's Advocate Mpofu, and that we should proceed on that basis. This continuous interjection disturbs the flow of the questions. Thanks.
Okay.
Chair.
Thank you. Honorable Gonda.
Chair, I was also going to ask that the public should not answer on behalf of the witness. If she wants to take the witness stand, she must come and let us know that she's ready to take the witness stand, but she must not answer on behalf of the witness. She's not on the stand. The witness is on the stand.
You're referring to the voice that you had. Okay. Thank you, Honorable. Just as I go to Advocate Bauer to proceed, quick, Advocate Mpofu.
Yeah, no, Chairperson, I object to all those three inputs, particularly the last one. I was objecting in the strongest possible terms. How does Honorable Gonde know who was speaking? Is she now a voice expert as well? There are 4 or 5 people who are here. Please, let's not just make a habit of insulting the public protector, you know, at your whim. Please, I'd like her to withdraw that statement or substantiate it.
I'm not going to withdraw that.
Chairperson, are you?
Just
who's the chairperson now? Who's the chairperson now? Is it you or Honorable Gonde?
Just conclude, Advocate Mpofu. I will attend to the issues.
All right. So, please, I'd like that insult to be withdrawn. other two members, the other two from the ANC, unfortunately, it is my job to raise objections. I know that there's a view that there should not be legal representation for the public protector, but unfortunately, the Constitutional Court found otherwise. And the objection that I raised earlier, I even said I'm raising it so that in the future, we don't have to avoid exactly what the members are talking about. Because otherwise, every time there's cross-examination, I'm going to object. I can assure you that 1000% if there is cross-examination. I'm not going to be silenced from that. So, and that's why Honorable Heron's input, my input, and the chair's input, in my view, was constructive to say that issue must be looked at holistically and maybe even have a relook at the directives to avoid exactly constant interjections every time such a question is asked, which will otherwise be the case. I can assure you that that's what will happen. So I don't know about me being silenced now from interjecting. In fact, you just want to blame the victim. If there are objectionable questions, you can't blame the person who's objecting. You must blame the person who's asking those objectionable questions. So maybe that's where you should direct your anger or vitriol. Yeah. So so that's what's going to happen until the end of this inquiry. If we find that there's a reason to object, a legitimate reason to object, we will do so because we have a right to do so. We must just deal with it.
Thank you, Advocate Mpofu. I think you have.
Let's deal with Chair. Let's deal with it. He says we must
I did not recognize you, Honorable Nkosi. You have ventilated and canvassed the point, Advocate Mpofu. Just from the chair, I think the issue was a request that that there be a flow of this interaction between Advocate Bauer and the witness.
Sure.
I agree with you that you have the right when recognized by the chair to at any point to come in if there's an issue that you're not clear about or you object to or disagree with, because that's part of the inquiry itself. So there shouldn't be any problem with that. There's no suggestion of you being silenced in playing that role. And I wouldn't allow that as a chair for you to mute and never say anything when you feel there's something to raise. It will be wrong for the inquiry to proceed in that manner. I want us, because the request is more about limiting the interjections, especially those that would not necessarily relate to what has been raised with the witness. But there is no way that we will ask you to keep quiet and not say anything until you take the stand. So let me first make that point. The second point I want to make is Honorable Gondwe, may address you now. I have referred to an echo that was coming there in the public protector and the legal team space where they are. I avoided mentioning any names, even if I felt like I know this voice. It's important so that we don't get into any guesswork in that regard. So I kept on making the point that whoever that voice is, and I think you've just gone further and say the public protector must, because you feel like it is the public protector speaking, but I wouldn't want you to go to that level because there's a voice we're hearing. Doesn't matter how similar the voice is, so that we stay on doing things proper. So I want you to refrain doing that. Thank you, colleagues. Advocate Bauer.
Chair, as long as we're on the same table, that this is not part of my minutes.
You're not the chair. The chair is taking care of those. Thank you.
Mr. Mataboge, the last question that I posed, are you there, Mr. Mataboge?
I'm here with Baba, here.
The last question that I posed, I asked whether you were aware that Mr. Senego is an attorney.
Not sure. I'm not sure of that.
So in which context do you know Mr. Senego?
I know Mr. Sano through our legal services. I don't know what context there is that with Baba referring to.
Mr. Mataboge, have you prior to becoming employed at the Public Protector's Office, were you a practicing attorney or advocate?
No, I'm just a legal graduate. I'm not admitted.
Do you know the difference between an attorney and an advocate?
I don't get the question. Do you know the difference between attorney and an advocate?
Yes. Do you know what is the
Yes,
distinction between an attorney and an advocate?
Yes, I know.
And what is
I
that?
think I know, yes.
Just repeat that. I didn't get it. The last response.
I was saying I know the difference, Chairperson.
Okay, thank you.
So would you know that an attorney wouldn't have an appellation SC?
No, I wouldn't know that.
Okay. So this opinion that was obtained from Mr. Senego, this opinion was provided you at which point, Mr. Mataboge?
It was provided at the beginning of the Sasa investigation through our legal services, not directly from Mr. Sianeo himself.
Right. So were you?
It was a written legal.
I don't have the reference to the email, but I will provide it to Advocate Mpofu in the course of it. Are you aware that the opinion had been secured through Mr. Senego securing the services of Mr. Nkubeni to write this opinion?
No, that one I wouldn't know.
And to that effect, the public protector had consulted with Mr. Nkubeni in respect thereof.
In my response, I would even ask who's Nkubeni. I may ask back the question, even though I'm trying to say I don't know who he is really.
Sorry. So the question I'm asking, you were not party to the consultation with Mr. Nkubeni in the discussion of the provision of the Busasa opinion?
Not at all. I wouldn't even point him out if I were to meet him.
Sorry, I didn't get that, Mr. Mataboge.
I say not at all. I would not even be able to point him out if I were to meet him.
But I said Mr. Nkubeni and you said Advocate Nkubeni. So what makes you say Advocate Nkubeni?
Chairperson.
It's a fair question.
Yes, I'm looking both.
But that's what you said, Advocate Bauer. That's what you said.
Yeah, no. Okay, Chairperson, really, this is, if you still call this not cross-examination, then it means,
no, Advocate Mpofu, let me immediately rule that's not cross-examination. She's asking a question. She's asking a question.
Yeah. Yes,
not cross-examination. I want to rule on that and let's proceed.
Please, can I speak, please? Yeah, Chairperson, that thing called cross-examination is made up of questions, okay? It's just the type of questions. It's not whether it's a question or cross-examination. There's no such distinction. Cross-examination is, by definition, questions, but it's certain types of questions. So I don't know what you are trying to say here. So I'm saying that what these questions that are being asked, so I agree with you, she's asking questions, but the questions, the manner in which she's asking the questions is called cross-examination.
Advocate Mpofu?
Yeah,
I think
no,
let's-
just
let's
wait,
not-
Chairperson. This is important. This is very important. It's not your fault, as I said earlier, but you just have to allow me to make my point here. I'm saying that what is happening now of interrogating the witness about some 2 letters, SC just means senior counsel. And now we're into Ngobeni and this one and that one. That's cross-examination, whether you like it or not. And I'm just registering
Okay.
it. You can then make your
Okay.
ruling. Thank you, Chair. Sorry.
Thank you. Thank you, Advocate Mpofu. I accept that you've reached at that point. I maintain that that's not cross-examination. There are a series of questions being asked, and sometimes they are asked differently. And I want Advocate Bauer to continue with their line of questioning. Thank you, Advocate Bauer.
Mr. Mataboge, I asked you the last question. I called him Mr. Ngubeni and you responded by saying Advocate Ngubeni. And so I wanted to know what informed your calling him Advocate Ngubeni.
I did not say that, Dr. Bauer. You're the one who said Mr. Saneho sourced the opinion from Advocate Ngubeni. I didn't start by calling it Advocate Ngubeni. If the record would show.
Okay. We'll check the record if I heard you wrong. If I heard you wrong, Mr. Mataboge, I apologize.
Okay, proceed.
So this opinion was obtained through your legal services. And I just want to be sure that we're talking about the right opinion. And I'm just going to ask Shepo to put it on the screen. It would be bundle F, item 96. There's one that's redacted, just like the redacted one. And go to 2123.126. Go to the bookmark. Yeah, okay, go 2123.126. Right. So if you just, sorry, Shepo, you have to go up to the first page so that we can, Mr. Mataboge can identify whether that's the opinion he's referring to. So just scroll up. Yeah. No, of 123.126, just scroll up to the first page of the opinion. Go to 2123.1220 should be that. Yeah. Okay. Just go down. Is this the opinion you're referring to, Mr. Mataboge?
Yeah. Yes, that is correct.
Right. I just want to, while we're on the subject, so that we can save time later, I want to take you to page 126. It's paragraph 3.23, Shepo. That's where you were a second ago. All right. And if you go down to 3.23, Mr. Mataboge, you and I will come to that, but there's a debate about how section 2.3 of the Executive Ethics Code is to be phrased. We'll come to that in a moment, but just for now, we'll note that in the opinion at 3.231, the phraseology used is deliberately or inadvertently mislead the president or the premier, as the case may be, the legislature. Correct?
Correct.
And then if we go to 3.48, it quotes the section. Hold on. It's page 132. Go down. 3.8 probably. There we go. At the bottom, it says, likewise, the South African Code states at 2.3 that members may not deliberately or inadvertently mislead the president or the premier, as the case may be, the legislature. You see that?
I see that, yes.
Right? But is silent as to the right to correct even inadvertent errors. And then it adds, it goes without saying that ministers who knowingly mislead Parliament would be expected to resign when caught. However, inadvertent misrepresentations are likely to be treated more leniently. Right? Right. So now if we can just go back to where we were, we've digressed into this opinion. I want to take you back to the report, which is at bundle E, and we're going to go to 246 onwards. Bundle E, the number 7, I think it is. Just check. 7.4, that's right. (246). And for the most part, Mr. Mataboge, so you know where we're going, I'm going to take you to aspects of the report and then we will digress if there are other documents that relate to the same substance of the report. Right? So at paragraph 246 onwards, if we go to 4.4, move down a bit. Right? This refers to the key sources of information that you would have had regard to for purposes of the preparation of the report. And we're now in the SARS unit report. Would you agree?
Yes.
Right. And in that list of documents that you have, what is not listed there is the complaint from the anonymous complainant that came in during October. Is there a reason why that was omitted?
That would have been inadvertent if it's not, like I see it's not here, because if you look at 4412, there's letters to the complainants, not only one. It was including the other complainant as well, I believe. And the complaint from the other complainant, I believe it was an email. It was not a letter that would have come in as a complaint. So I think it was inadvertently not listed here as an email complaint.
Right. You would accept that the complaint should have been listed there?
Yes, I agree.
What is also not listed there is the classified IGI report that had been prepared by the late Ms. Radebe. Would you agree with that? We can go into the whys and but let's just get the principle out of the way that's not there.
Yes, it's not there, yes.
Right. What is there from 4415 downwards, Shepo, if you could just scroll it down, is the correspondence which ensued with the office of the IGI and the subpoena that had been issued to the Minister of State Security, correct?
That is correct.
Right. Now, if we go to 4.4129, right, 4.4129. No, that's 9, not 29. Right. You talk about further documents blurred and or not listed due to their nature. What are you referring to here? And let me understand my phraseology correct for the record. I don't mean you personally. Me and you, Mr. Mataboge, we accept that this is a report of the public protector, correct?
Yes.
So I'm asking
I
you
think
to...
Yes. I wanted to respond to that. There would have been information that relate to people's IDs and so forth, as well as things that we think were personal, then we have to blur them and not show their personal information. And that's why I say it's said here due to their nature.
Okay, so it's for example, I think in the report there's equipment or things that are blurred in the report. That would be probably the documents that would be included in that. Would that be fair?
Yes.
Right. Then you had copies of documents submitted by former employees of SARS. If we go up again. Right. There we go, 44125. Copies of documents submitted by former employees of SARS, the intelligence unit. Were those documents submitted directly to you?
They would have been submitted to the investigation team.
They were submitted to the investigation team.
Yes.
Okay, so yeah, and how were they submitted?
I'll have to check that because it would mean that they would have been brought here or emailed, because I remember some of them related to the what is that, the equipment that related to the unit and so forth.
Did you have any meetings with former employees of SARS for purposes of the investigation?
We would have had not with all of them, because I remember we had to get the information on the HR files. We had meetings with the current staff of SARS, not the former per se.
So if we go down, we're not talking about the members who were subpoenaed to appear, which we see further down in the document, the notices that had been issued to the minister. Go down. Mr. Magashunu, we don't see any meetings listed in the report with any specific people. Would you ordinarily list it if you had meetings?
Not really, because if a person would have come through our reception and we got called to meet with him, or it would not be a meeting, we'd come and drop off documents, for instance, then we would not have listed it here, because it's not a formal meeting wherein we would have have kept the audio recordings of the meeting.
So for formal meetings, you would have to keep the recordings.
Yes.
Now in 4.421, you list the recordings relating to the 21, 4.421. It's 4.2, sorry, 4.4.2. 4.4.2.1, go down, Shepo. Your recordings relating to the operations of the intelligence unit. Were those recordings that you made, or were those recordings that you got?
No, these ones we got.
And where did you get them from?
From the like I said, we have one or two of former employees come in and give us information, and I wouldn't want to say who brought them in particular. I wouldn't remember, but we had those recordings.
Right. And what did you do to authenticate these recordings?
We did not authenticate them. We did not do anything to authenticate them.
So you relied on these recordings that were brought into your office without any authentication?
If that's what it means, yes.
Can I just, while we're on this page, I'm going to come to Shepo, just go back up. I saw something that I want to raise with him later, but we can just, while we're in the report, it will save time. Go to 4.4.19, 119. Just so that we can see, sorry, it's 4.4.1.21. There is correspondence from SARS by Mr. Mark Kingdon dated 5 February 2019. If it's listed here, you would have had it. Is that correct, Mr. Mataboge? Again, I mean you in the sense of the investigative unit and the public protector.
You mean what would have been listed here at February? The recordings?
No, let me phrase it more broadly. Everything that is listed here is documentation or recordings or correspondence that you had in your possession as the public protector.
Correct, yes.
And the investigation being conducted by Ms. Mvuyana and by you as the chief investigator, you would also have had those in your possession.
Yes, in the file.
Now, what you don't see here, Mr. Mataboge, is any reference to an affidavit by Mr. Lebello.
Yes, I don't see it either, yes.
Now, was that an oversight or was that deliberate?
I don't get it that because we never had an affidavit. I never saw an affidavit from Mr. Rivero.
It was given to you. Can we go to page 6072? It would be the 190s. Bundle F, Shepherd knows where it is. $6072. This is an email dated 7th December 2018 from Advocate Nkubani to yourself and Ms. Mukhaladi. Do you see that?
I'm looking at it, yes.
And if you scroll down, there's an attachment. And the attachment is a supplementary affidavit from Mr. Lebella before the Nugent inquiry. Have you not seen this before?
Yes. No, I haven't seen it.
And
I believe it's an oversight on my part because I look at it unless I don't remember it, but I have not seen it.
Now, if we go, you will recall that there was a request to the Public Protector's Office, to the CEO for documentation, and that documentation was provided and they are contained in 189, the bundle 189, and listed in that document is the list of documentation that has been provided to the evidence leaders at 189.45. I asked you yesterday, and I tried to remember, I asked you on whichever day it was, Tuesday, whether you had been involved in the compilation of putting together this to provide to evidence leaders. Can you remind me what your answer was, Mr. Mataboge?
Yes, my answer was that the investigator as well as the admin assistant were the ones who were involved in the compilation of the list. And my role was when they said they were satisfied, I looked at it and submitted it through to the CEO's office for transmission to the evidence leaders. Yes.
Can we go to the last page of the document at 4984? It's 189.45. And it's the last page of that document. Yeah. And number 1 says, notes on meeting with Mr. Labello, SARS dated 11 December 2018, appears to relate to Pillay pension complaint and EFF complaint. You see that, Mr. Mataboge? Does that ring a bell?
It does a bit, but now I think here there would be a problem with my memory, because there was 2 files on the Mr. Pilay's appointment pension complaint, as well as the one relating to the unit. So when this affidavit is referred to, it would have been in the other file that is not the same as this one that relates to the unit.
You would be aware that the inquiry before Judge Nugent related to this matter and not the pension complaint.
Yes, I would be aware.
And there was clearly an interview with Mr. Labello dated 11 December 2018. Because there's notes of
yes, there would have been, yes.
And do you think it would be fair to expect that that would have been referred to both in the report and in the Rule 53 record?
It would have been fair, yes.
And in fact, at some point, do you not recall Mr. Labello's affidavit at all?
I'm trying, I'm not.
Maybe
I'm not
I'll ask. Okay, I'll give you an opportunity to maybe look over it overnight and see if you can then remember you. You will recall that during this process, Minister Gordhan asked the public protector for an opportunity to interview witnesses. Do you recall that?
Yes, I think it was in a meeting with him, I think.
And he was informed that there were no witnesses.
I wouldn't know that. I wouldn't remember that exactly.
Now, we also know, if we go back to the source documents of the opinion of the report, the SARS unit report, there is no mention in respect of the Nugent inquiry report either.
Yes.
Right? Does that mean you didn't have regard to the Nugent inquiry report?
Yes, because we had a consideration of it, but it was not our source document as compared to the other report. Yes.
So what does it mean you had consideration of it?
It means we knew of it, we knew what it related to, but it was not the primary focus report for us.
What does a primary focus report mean? I'm not trying to be difficult, Mr. Mataboge. I'm just trying to understand how you determine which reports to have regard to and which reports not to. So when you say it was not your primary focus, perhaps you can explain how that determination gets made, or how the PP makes that determination.
When we get evidence and we get to investigate, the source document that we rely on, it really is in the discretion of the PPU as to what we use, and we may choose to use the KPMG report or Sikagan report as against the Nugent report for various reasons. For instance, the Nugent report was, in my view, it looked like it was a commission, and its contents and recommendations were not like they had no binding and effect and so forth. It was more of an opinion. But that is not the reason. I'm just answering as to why sometimes we'd be taking another source document as compared to taking the other, you know.
Okay, so one of the questions that had been posed to you, if Shepherd just goes up, on the Nugent inquiry, if we just go up, I'll tell you which number it is. Go. There we go, 3.10. Information why the Nugent report was not considered or dealt with. The answer was no information. Verbal discussion with PP and investigation team. What does it mean, no information?
It means there's because the question says information why Nugent report was not considered, and I'm saying no information, but I don't know who wrote that, because it looks like somebody wrote what I was saying, but no information means nothing was considered from the Nugent report, I think.
Okay, but we've now already established that at the very least you had the affidavit of Mr. Lebello from the Nugent inquiry before you. And then on this note, it says, reason that the findings of the Nugent report were not binding and could not be relied on. That accords with what you said to me earlier.
Yeah, that's what I was getting at, yes.
And if you had the Nugent report inquiry and you had regard to it, would you have expected that it formed part of the Rule 53 record?
Yes, it would have.
And it's not part of the 53 record. So how do you explain that, Mr. Mataboge?
Can you repeat the question? Maybe I listed.
If we look at the Rule 53 record, if we look at the Rule 53 record, and maybe to make it easier for you, I'll tell Shepherd to go there. It's bundle E. And it would be number 7. And it would be number 9. There was an initial Rule 53 record filed and then a supplementary Rule 53 record filed. And if we go to the index of the Rule 53 record, which starts on page 6, and I'm saying to you, Mr. Mataboge, it follows largely your documentation as reflected in the report, and there's no reference to the Nugent Commission report either there or in the supplementary index, which you find at page 1080.
Yes.
And I'm saying to you, should the Nugent Commission report, if you had regard to it, not have been included in the Rule 53 record?
Yes, if we had regard to it, if we used it, Advocate Power, it would have been part of the Rule 53 report, but it was not used by the investigation team.
Did you consider it at all, Mr. Mataboge?
No, we didn't consider it. We didn't consider it in the sense of us, going through it and relying and reading and analyzing it in that context. That is why it did not have been part of, because we put the document that we considered and even cited in our reports in the Rule 53 document.
I'm coming back to that. I just want to take you to the reference. It would be 5935, just so that the committee can see it. It's the response, Minister Godin's response to the Section 7I notice on 21 June 2019. It would be the 190s. Just 5935. It would be 190.2, I think. Oh, 0.1. Minister Godan said that he was entitled to question other witnesses determined by the public protector who have appeared before in the course of the investigation in this matter. And he asked to exercise that right. Correct?
Yes.
That would mean not only witnesses that appeared before the public protector per se, but witnesses who gave evidence to the investigator at the public protector's office as well. Would you agree?
Can you repeat the question because it's convoluted for me?
Okay, so the minister comes and he says, I want to have an opportunity to question witnesses. Those
Yes.
witnesses would be witnesses from whom the public protector obtained evidence that informed the Section 7(9) notice. Would you agree?
Yes.
That would not be limited to witnesses who the public protector personally interviewed. It would also include witnesses or members of the investigating team interviewed.
Yes, I agree.
Agreed. So if you interviewed Mr. Lebelo on the 11th of December, then Minister Godan should have been afforded an opportunity to question him as a matter of principle. Would you agree?
Yes, but if I may qualify that, nobody was interviewed by Minister Godan, consequently, not only in respect of Mr. Lebelo, I think, if I recall well.
No. Wouldn't Mr. Godan have had a right to interview Mr. Lebelo if the PP's investigative team had interviewed Mr. Lebelo?
I think we need to refer to the section that relates to the subpoena as to who had brought evidence in terms of the subpoena to the PP may then be questioned by the respondent. I'm not sure about the applicable section there. It's not
Section
everyone
7(9). Sorry, Chairperson. I'm sorry, Chair. Sorry, Mr. Mataboge. It's section 7(9), Chairperson.
Thank you for your assistance, Advocate Mpofu.
What is it you want to refer me to, Mr. Mataboge? Should I assist you by putting section 7(9) on the screen?
I'm looking at it. I have it in my office. I'm looking at it.
Relating to
Sorry, Chair, I don't have it in front of me, but it's one of the Roman figures that relates to witnesses.
It's section 7(9)(b)(2), and
Roman
it reads, such person or his or her legal representative shall be entitled through the public protector to question other witnesses determined by the public protector who have appeared before the public protector in terms of the section.
Yeah, thank you. It's that one.
So how I understand it, Bauer, is that those people would have been the ones that also appeared before the PP under this section 7(9).
Okay, so you're saying that the minister is not afforded an opportunity to interview witnesses who implicates it's only in respect of people under 7(9) who comes before the public protector that Minister Godan would have been entitled to interview. Is that what you're saying?
That's what I'm saying.
So, Mr. Mataboge, neither the affidavit of Mr. Lebello nor the IGI report was included in the, nor the Nugent report was included in the Rule 53 record. Do you agree?
I do agree.
Now, if you then go to the meeting, which then transpires with Mr. Floyd Shivambo, you have not been able to find the recording of that meeting, correct?
Yes, we have not been able to find them.
And there was no
The meeting of
recording that
December.
the meeting of December.
Excuse me, Edward. Excuse me, Edward. You mean the one for December 2018?
December 2018.
Yes, we have not been able to get it.
Sorry, Mr. Mataboge, I mustn't do this because it's going to mess up the transcript. I must endeavor to, in my endeavor to speed up things, I'm talking across you. I apologize to do that. Let me ask this meeting of December 2018, you attended this meeting, correct?
Yes.
Right. There was no recording of this meeting that formed part of the Rule 53 record.
Yes, it looks like there was no audio. I'm wondering if I can't recall properly. I'm wondering if I had not been able to submit my notes because I normally keep notes for such meetings. Are you able to hear me?
I think.
Yes, yes, we can hear you.
Your notes have been provided to us, but I stand corrected. I'm not sure. Your notes are not very comprehensive, Mr. Mataboge. You know what you're writing and what you mean by it. But for the other party, I'm just checking on the recording. In the ordinary course, this meeting should have been recorded, correct?
Yes.
And the response that we given in the document, which I took you to earlier, 189.45, it's written, we don't need to go there. We are still searching for the recording as we do not recall if the meeting was recorded.
Correct, Edward.
Now, you were aware of the relevance, and shall we call it the IGI report in January already, the January of 2019? Would that be so?
Why would you call it that, Edward Power? Why would I accept that it be called that?
No, it's the Inspector General of Intelligence report. Can we just, for our purposes of interaction, call a report that had been prepared by Ms. Radebe, the IGI report, for purposes of the questions that I'm going to ask you?
Okay, yes.
All right, okay. So let's just for ease do that. If you prefer calling it something else, we can, but I just, for the record purposes, let's just stick to one name. And I'm saying to you, you were aware of the relevance of this report from January of 2019 already.
Yes, I think because there were communications between the Inspector General and the Public Protector on the investigation. Yes.
In fact, you were the author of this communication initially. I don't know if you were the author of all, but the initial communication, you were the author.
Which communication? Can you elaborate that?
Okay, let me take you to bundle 190.2, page 6208. Yeah.
Can you get it, Seppo? You
Yes.
don't seem confident.
190.2, 6208. This is an email you receive on the 4th of January from Mr. Sibusise Niembi. Do you see that?
I see that, yes.
And he tells you He is the newly recruited Chief of Staff. And he hopes to meet and greet you in person sometime the next week,
Yes.
right? And if we go down, he tells you that during December of 2018, the PP was informed or received information that there is a report that was issued by the Office of the Inspector General of Intelligence that dated 31 October 2014, which I referred to as the IGI report for ease of convenience, and signed by Ambassador Advocate FD Hadebi. I think, yeah, that should be
Yes.
Radebi. The Office of Inspector General has jurisdiction to investigate matters relating to the State Security Agency, SS, and its functioning. You would accept that the SARS unit and the matters of the SSA are separate. Would you agree?
Yes.
Right. The report pertains to the investigation that was undertaken following then media allegations relating the Special Operations Unit and other branches of the SSA. The information at PP's disposal suggests the said report is relevant to the investigation currently underway regards Minister Gordhan. And so I put it to you that you were made aware in January already that this IGI report had relevance to the investigation. Do you agree with that?
Yes.
Right. You were then asked to prepare a letter for the signature of the PP, formally requesting the aforementioned report from the Office of the Inspector General and or the SSA itself. That is why I suggested you authored this letter.
Yes, I would have authored, as a preparer, I would have prepared the letters that would go through the normal channels for PP's approval. Yes, I would have.
That's correct. Now I'm asking you, as at that date of 4th January, as far as you had knowledge, was this IGI report in the Public Protector's possession?
No, I wouldn't know. I don't think so, because when we had an engagement with the Inspector General, the report had not been in the PP's possession, because we had a meeting in one instance with the PP, with Mr. Dindwe or Dr. Dindwe.
Yeah, Mr. Mataboge, I don't want to confuse you, so let me take this through chronologically. It's been a few years, and so I want you we'll get to that meeting. Are you referring to the meeting of the 31st of January?
Yes, and I'm looking into my records.
Did Advocate Mpofu want to say something? Oh, sorry.
Yes.
Oh, no, there's no hand of Advocate Mpofu.
Oh, so yeah, sorry, Chair. Can I use my voice as my hand?
Well, that's a new arrangement. We use hands, but I will allow you.
Okay,
for now.
there's the black hand there. Thank you. No, Chair, I wanted to just, I won't call it assisting, but because I've also had this confusion in my head, it might. There's the issue of the so-called declassified what do you call it, report, IGI report, which is what the fight was all about. And then there's the other report, which was allegedly anonymously dropped. So I'm just saying, if it will assist Advocate Bob, because I've also had that confusion many times. It's that when it's just say the report, I think there's the issue of whether it was the one that there was litigation over or threats of litigation over, namely the declassified report, or the one that was anonymously dropped. Thank you, Chair.
Advocate Mpofu, Advocate
Thank
Bawa.
you, Advocate Mpofu. But we're now at January 2019. As far as I'm aware, the declassified report was only provided on the 9th of November 2019. So I am, if it helps Mr. Mataboge, I'm only referring to what is in existence in January 2019, which is a classified IGI report. And as Advocate Mpofu has reminded you, it was the one that is been said to have been dropped anonymously at the PP's office. Right. So I was asking you whether, as at the 4th of January, the public protector, as far as you were aware, had been in possession of the classified IGI report.
No, Advocate Bawa was not aware at all.
Now, Advocate Mpofu reminded us about this anonymous whistleblower who we were said dropped the report off at the PP's office. When did you become aware of this anonymous whistleblower having dropped the report off at the PP's office as the chief investigator dealing with this matter?
I think when there was a meeting or interaction between the office of the Inspector General as well as the Minister for SSA, that is when the conversations went as far as that. That's when I became aware.
I want to take you to a document called, do you want me to continue? I'm happy to continue. I'm not the chair, I'm just, I'm going on to a section which is a discrete section.
Okay,
And
that's fine. If you want to pause it, it's 1 o'clock, correct? We'll take 45 minutes, colleagues, and be back at 1:45 from lunch. We'll take lunch for 45 minutes. Thank you. Back at 1:45, we pause.
Recording stopped.
colleagues. We now resume. The time now is 13:49, 13:50. Thank you for having a brief lunch. We're going to resume with Advocate Bauer, as I indicated. So she now needs to conclude, but I had indicated that 30 minutes was eaten away to start with. And then we had this network issue. So there would have been another 10 or 12 minutes into that. So I'm going to ask her to resume and take us to 3:15, 3:30. And then she will have to pause there. Thank you. Advocate Bauer.
Mr. Mataboge, are you there?
Afternoon, I'm here, good Bauer. I'm here.
I just want to close off on two issues that I dealt with before the lunch adjournment. If I take you to 185.45, which is at 4979 of the bundle, being the information that the office had provided me, I want to draw your attention to 1.2. We sought information regarding EMs and the input into reports and Section 79 notices relating to the Palace pension, the EMEA complaint, and the rogue unit report. And in response, we got was emails and drafts provided in terms of which Mr. Mataboge and Ms. Mvuyani corresponded regarding inputs on the drafts, including PP's inputs. Does not appear anything from the EMs. That's the one I want to take you to. The second thing I want to take you to is at 2.1, which confirms what you have said to us, the name of the EM who at times supervised investigation and attended to quality assurance. You had testified that there wasn't any. And then on the third category, which relates to the SARS unit report, if I take you to 3.9, you will see that they tell us memo trails and emails in the Godani investigations on draft puts in 7.9, and none of the documentation provided to us emanates from an EM or a CEO commenting on the Section 7.9 notice and reports. I understand you said you've got something, but on the information that's been provided in the document which you had settled, there is nothing provided to us on that notice. Do you see that, Mr. Mataboge?
I see that, but I'm seeing this document for the first time though. But I see what he's saying there, and where I disagreed with it, I'll have to go to my memos and my emails and resend.
Mr. Mataboge, just take you to the top of this document. I don't understand how you're telling me you're seeing this document for the first time when earlier on you had said to me it had been compiled by the investigator, you had approved it, and then it was sent to us.
I'm saying that the document, even the heading at the top there, it is not the heading that comes from our side, from our office. That's why I'm seeing it. It doesn't look familiar to me, in short.
So in other words, Mr. Mataboge, you did not, contrary to what you said to me this morning, provide input into the answers that was provided to us following the question sought.
No, I did. I'm talking about the document itself. I did, I'm talking about the look of the document as I identified now.
Okay, so do you know who compiled this document?
I wouldn't know. I'll have to check, because we normally send the document based on the Rule 53. But whoever compiled this, I'll have to find out from the office. Because I even thought that it may have been compiled by the evidence leaders having been in an interview with me. But now what you're saying looks like the document comes from the PPSA.
It does come from the PPSA. We addressed a letter to the CEO, and this was the response we got.
Yes,
You will recall, Mr.
Go ahead, Dr. Bauer.
Yeah, sorry. And the other thing, the second thing I wanted to clarify with you, and I might have just misled you, and that's why I want to take you back to it, is in the report when we were talking about the source documents at 4.4 of the report. If I take you to page 248 of the report, right? At 4421. Yeah, it's 248. Yeah. This recordings, when we talk about an intelligence unit, are you referring to the SARS intelligence unit or are you talking to the SSA intelligence unit?
Is the one that related to the SARS. It's not the intelligence, the SSA one.
So just so that I can clear up, because I didn't want to confuse it with the recording of the meeting of the 31st of January. And so that's why I'm checking with you whether this was recordings that you obtained elsewhere.
No, it was not for the meeting of the 31st.
Okay. Thank you. So if we go back and where I left off just before the lunch adjournment, you will be aware that there was an article published in Newsweek.
Yes, I was aware.
Right, the IGI report. And Mr. Shivambo provided Ms. Simpuyani with a copy of the Newsweek article.
Yes.
On the 24th of January, 2019. Did she provide you with a copy thereof?
Yes.
And in fact, if the public protector also shared it with you in an email a few months later. Do you recall that?
Yes.
Right. Now, at the time when you got this Newsweek article, did you have the classified IGI report?
I never had the classified or unclassified IGI report, and I never had sight of it, as I said to you when I consulted with you and Advocate Manyosi. I had never had sight of it.
Now, if one has regard to the Newsweek article, and if we can just put it on the screen. It's 4357. Go down. So this is the article you obtained?
Yes.
Right. And the Newsweek article, if you go down, Chepo. It refers in the article, go down. Just stop at the first page. It refers to an article in it, in the third paragraph, refers to a 62-page report that had remained classified secret. And it says that Newsweek is finally able to reveal its contents. You see that?
I see that, yes.
Right. And it then refers, if you go up, in the third paragraph, it refers to Mr. Adrian Lakay, who in 2025, a SARS former press spokesman, he had resigned. Go down, right? And then he had put out a statement through the DA revealing the opening portion of the testimony of the controversial units leader, Johan van Lachenberg, to the secret investigation. And he tells you, Van Lachenberg said Lekay had presented 34 related instances to Inspector General Radebe and identified over 60 individuals he believed should be interviewed. He provided the IGI with multiple data and evidence, including a memory stick containing whatever information data is in his possession. Do you see that?
I'm looking at it, Rico, but why are you saying he tells me? He tells you. He didn't. Why you say that he tells you?
The article tells you this. You have in your possession this article. This newspaper article
Yes,
tells this. I'm not talking about the accuracy or the veracity of the article. There is an article that tells you, here is a person who's got this information that he had provided to the Inspector General in respect of the subject matter of your investigation. Do you see that?
Yes, I'm looking at it, but I still deny the fact that you seem to suggest that this Lekay was telling me or telling us as investigators.
No. Sorry,
And
the
yet
reader of the article. Sorry, let me get right. You got this article. When you get this article, do you read this article, Mr. Mataboge?
No, I didn't read it.
Why do you not read it?
Like I was saying, when I investigate, I want to focus. I don't consider many things that I would consider distractions, especially during an investigation, where at the end of the day you might be or driven towards a particular direction. I remember Advocate saying she had read it. I did not read it so much in detail or even consider it that much personally.
So, Advocate Bauer, you're referring to the reader of the article, not to Mr. Mataboge.
That's right. But
okay,
Mr. Mataboge, when the public protector passes information on to you, do you read it?
Yes, if it's coming from public, I do read it, yes.
Right. So let me take you to 190.1, page 5889. You see there on the 27th of April, the public protector provides you with the Newsweek article.
Yes, I see it, Rebecca.
Did you read it, Mr. Mataboge?
Not so much in detail. I read it and glanced it over and put it in the file and left it to Ms. Viana, yes.
So as part of this investigation between yourself, the public protector, and the other investigator, you had a Newsweek article that told you that the head of this alleged SARS unit had all this information in his possession. Would that be fair?
Yes.
Right, let's go back to this article. We can put it as if you had read this article, you would reasonably have known this information, correct?
Yes.
In fact, this article tells you that Mr. van Lachenberg is identified as the head of this alleged illegal intelligence unit. Did you know that, Mr. Mataboge?
No, I didn't know that.
You conducted this investigation into this alleged intelligence unit and you didn't know that Mr. van Lachenberg was said to be the head of this unit.
I thought you meant, did I know it in respect of this article, the way the article is read, not in the context of him being part of the investigation, being the head.
So you knew it otherwise, but you didn't know it in the context of this article.
Yes.
If you then go to page 15 of this article, you will find going down, there is a list of what is regarded as some of, in the second column, some of the Inspector General's more notable findings in the secret report. But you wouldn't have known this because you didn't read this article. Is that correct?
Yes, even now I'm seeing it for the first time. Yes.
And the article then further goes on in the last column. It is clear that the source for the Inspector General's report is a document circulated years ago by a controversial former member of the COVID SARS unit named Michael Piecha. Do you know that name, Mr. Mataboge?
Yes.
How do you know that name?
Because it was mentioned to us at some point by the PPS as the people that we needed to interview.
And did you interview him?
No, I could not get hold of him. No.
Did you interview anybody who belonged to this unit?
We tried as well. There was one name that also was mentioned, a sort of a Russian name that was given, and we tried to trace him, not trace him as well. Yeah, I think it's Bioski or Bikoski or something to that effect.
So did you interview anybody that belonged or was alleged to have been a member of this unit? Yes, no, maybe?
No, I don't think so.
The article also tells you, if you go down, I think you must go to the next page. Go down. Down. Sorry, I think you must go further down. Hold on. Down. Down. Further down. Stop there just for a second. You would have also known, had you read this article, I think it's a little bit further down. That Mr. Pillay and Mr. van Lagenberg was facing criminal charges. Did you know that, Mr. Mataboge? Go further down.
No, I would not know that, except when I once saw in the news reporting at the time, on television also.
So you didn't know that they were facing criminal charges?
Yes, until I saw it on the news coverage.
Were you the chief investigator in respect of the Pillay pension case as well?
Yes, I was.
And Mr. Pillay was interviewed during that period and he provided a statement, did he not?
Yes, he was for the pension fund matter, yes.
And would you have applied your mind and read the statement that Mr. Pillay had provided?
Naturally, yes. We've had to apply our minds to that.
I cannot put it up on the screen. I'm going to ask if it can be WhatsApp to you and to the PP's team. And I'll tell you now why. Because attached to the
Yes.
affidavit of Mr. Pillay is a copy of the criminal complaint against inter alia Mr. van Lachenberg and Mr. Pillay. And on the front page of that criminal complaint are the addresses at which Mr. Pillay and Mr. van Lachenberg could be found. And it was provided to you during the interview which Mr. Pillay had on the 24th of March, 2019. So you were in possession of the criminal charges against Mr. Pillay and Mr. van Lachenberg because it had been given to you by Mr. Pillay. Do you dispute that, Mr. Mataboge?
I don't let me see the document, and I don't dispute it. If it was given to us like that, I don't dispute it.
It's for the sake of completion. I'm going to give okay. It's part of the it's part of the record in the case number 360992081. It's part of the Rule 53 record, as part of the annexures provided in court, actually. But I don't want to waste my time taking you to that. Did the public protector ever ask you to get hold of Johan van Lachenberg?
Yes, she did.
And what did you do to get hold of him?
When she said we must try and locate him at that court, we wanted to invoke the subpoena that had been obtained and ask the messenger to try and serve him, but that did not happen.
Right. I'm going to come to it in a moment as to what transpired with the messenger. Right. Okay. Before we come to the messenger, you have this meeting on the 31st of January with the IGI inspector and that. If you take us to 5796, you prepare the questions for the PP for that meeting, correct?
Yes, Abba.
And initially, it's anticipated that the meeting would be attended by both the Minister of State Security and the IGI, but the Minister of State Security then postpones. Is that, you recall that?
Yes, that's correct, yes.
And you identify in that document, if you scroll down, Shepo, that the purpose of the meeting was to request the Minister and the IGI to produce a copy of the report.
Yes.
Right. And you prepared this without knowing anything further about the report, correct? Because you would not have read.
Correct.
You know nothing about
Yes.
it, but what the Niembis told you. Is that what I understand?
That is correct.
Right. And then you go to paragraph 3 of your note, 5.3. It says there, I've been reliably informed that your office conducted an investigation. Right? What do you base that reliably informed on?
I'm the preparer of the document, but this is the question prepared for the PP. I would say the PP will be able to answer that.
Okay, so you didn't write this?
I write the questions for the PP to then approve and go through. But when the narrative is, if I say I'm not the I. The I is the executive authority, which is the PP.
I'm aware of that, Mr. Mataboge, but we've seen several of this where the investigators prepare the questions for the PP in advance of a meeting, and they write the document as if they are writing it for the PP. Is that not what you're doing, Mr. Mataboge?
That is correct. That's what I'm saying. To say I would not have been the I in that question, or that this preparatory document.
You are not the I. You're not the I, but you are writing I. You are writing this for the PP.
Because the PP is the one that goes through it when she addresses meetings, not myself.
Now, Mr.
And
Mataboge,
that is how
sorry, just stop for a moment. Let me phrase the question properly.
Just to ask you talking cross purposes, maybe you need to be patient to allow him to finish before you come in. Thank you.
Mr. Mataboge, I apologize. I'm trying to correct you in saying you write this for the PP. She is the I. But at the time you write that, you are of the view that she had been reliably informed. How do you know she had been reliably informed?
I believe I would have consulted with PP before we prepare this thing, this document for the meeting. I would have had an engagement with her or an audience with her. I would not just write like that from my own thinking and volition.
Right. So now we go to 5803. Right. This is the letter that is received, go down, in response to the two previous letters that was written on the 8th and the 14th. Right? You see that?
I'm looking at it, yes.
What they confirm is that the Inspector General's office conducted an investigation into media allegations against the Special Operations Unit and the other branches of the State Security Agency in 2014. Would you agree that they are not confirming anything to do with SARS?
I'm not sure, not comment on that.
Mr. Mataboge, can you read paragraph 2 and tell me whether paragraph 2 relates to SARS at all? Or the rogue unit or anything related to SARS?
I'm reading it quietly, yes, I've read it.
Does that relate to SARS or the rogue unit at all?
No, it talks about SSA, no SARS here.
Right. And then it goes down into paragraph 3. It tells you in paragraph 3 who requested the report, and it further tells you, if you go down, that the import of it is that the Minister of State Security, as the tasking authority, is the lawful custodian of the report and the authority of its disclosure. Do you see that?
Yes, I do.
Right. If I go back up, and just so that we're very clear, you would agree that there's nothing about SARS in this letter?
Yes, there isn't.
Right. You are then on the very next day, if we go to 5805, there's an instruction given to subpoena the report from both the minister and also the office of the IGI. Do you see that?
Yes, I do.
And that is an instruction which comes from Mr. Kabinda.
Yes.
Kabinde. He's the, he would be giving that instruction on behalf, he's the personal assistant. He would be doing that on behalf of the public protector, correct?
That is correct.
Did you check the law at any stage as to whether the IGI is in a position to actually provide such a report? Before, do you advise the PP about this at all?
I would have checked. I would have checked the law.
And what would your conclusions have been on the law?
I believe the report would have been given in a redacted form according to the law.
No. Would the possessor of the report have been the office of the IGI who could lawfully provide the report to you, or the Minister of SSA?
No, it would have been the minister.
And so, but nonetheless, a subpoena went out to the IGI.
Yes, it went to both the minister as well as the IGI.
Now, you're present at this meeting on the 31st of January, correct?
Yes, I was. Yes, I was.
And there were, I think, Ms. Mokhaladi's there and the PP's there.
Yes.
And it is during this meeting that the PP informs the IGI about a classified report having been dropped at the PP's reception, correct?
Yes, I think I remember that.
Right. Did you see the report in this meeting at all?
Not at all, because in that meeting there were no reports exchanged on the day of the meeting. There were no documents exchanged.
And so the PP didn't take out the report and give it or show it to the Inspector General or to Advocate Governor at all?
No, I don't remember.
Your
I don't
presence?
remember that. Yes, not in my presence.
And were you taken aback that you had not been taken into the PP's confidence that she had this report that had been dropped off at the office and which she was now telling the IGI about?
I was not being taken aback because at my level, I'm not the executive authority. I'm a subordinate to the PP.
Okay, but you're the chief investigator in this matter.
Yes, I am.
Right. Then at 5:10, there's subsequently a meeting with the Minister of State Security. Were you present at this meeting? Took place on the 15th
Yes,
of
I
February.
was. Yes, I
Right.
was.
And then there's a letter at 5:10 of the documents. Now, it is so, and I don't think it's an issue that the public protector at this meeting tells the minister that she's in possession of a copy of this report, as she had done on 31 January. Do you recall that?
I don't recall that.
Okay, let me go down in the
I
letter.
don't recall that.
Okay. Do you recall seeing this letter of 20 February 2019?
Yes, I do.
Right. Now, that meeting with the Minister of State Security, would it have been recorded?
Yes, it would have been recorded, I recall.
And if it was recorded, should it have been part of the Rule 53 record?
It should have been, but because sometimes the recordings are kept by the PA in the PP's office, I would have had to check with Mr. Kabinde for him to avail it to us, because it was a meeting between the executive authority and the PP. But it should have been, as you correctly say, yes.
Mr. Mataboge, that would have had to be checked before submitting a Rule 53 record, correct?
Yes.
And you knew that this meeting took place because you were in it?
Yes.
And now if you go into this letter at paragraph 3. Wait, sorry, Shipper, let's go up. Let me not, in light of a...
Sorry, Chairperson, I'm sorry.
Okay, pause Advocate Power, Advocate Mpofu.
Yes, so sorry, Advocate Bauer, maybe I was not paying attention. Just making sure, was that last proposition, was that Mr. Mataboge was part of the meeting between the public protector and the minister? Is that what?
That's what I asked, and he said yes. Do you have different instructions, Mr. Advocate Mpofu?
Yes, I do, but your question was not clear. I think that's fine. All right. I wanted just to check if that was indeed your question.
It was.
Thank you, Advocate Mpofu.
I'll ask him again because I also didn't understand him to be there. But
go ahead.
Well, then it's your duty as the evidence leader, if you don't understand him to be there, to clarify that, not to just leave.
No, hold on. Advocate Mpofu, I'm about to do that. Just hold on. I don't have any.
When were you going to do it if I didn't raise it? Thank you, Chair.
No, hold on, Advocate Mpofu. I'm going to the letter to do this. Just hold on a sec. I don't have any documentation or information or a recording or a minute of this meeting as to who was there or not. But Mr. Mataboge, let's go to this.
I'm sorry. I'm really sorry, Advocate Bauer. Chair, I really want to raise this issue very sharply. Advocate Bauer is an evidence leader, not a prosecutor. So if she says her own understanding was that the witness was not in the meeting, and she says the witness answered yes, he was there, her duty to the committee is then to clarify that, not to want to take advantage of what might be the wrong answer or maybe the wrong question even, because that's the kind of thing that's done by someone who's pursuing a particular agenda.
Okay, thank you, Advocate Mpofu. Place your issue. Advocate Bauer, please.
Chair, my understanding is that it could be wrong. The witness could be right, because I get my understanding from interviews with other witnesses that we have who says they were not in the meeting, but they think he was there. Who's going to know better whether he was there or not? I was going to ask him, look at the first paragraph, which I took him back up, and then I'm going to pose the question again to be sure. Advocate Mpofu was a bit too quick off the... I was going to paragraph 3 and I took it back to paragraph 1. So can we just go to paragraph 1?
Okay, let's proceed.
So, Mr. Mataboge, I was referring in paragraph 1, which is where I was taking you back to, that this was a meeting between the Public Protector South Africa and the Minister of State Security, Ms. Letsasi Duba, concerning the report of the Inspector General into allegations against the Special Operations Unit and the other branches of the State Security Agency, dated 31 October, and it took place on 15 February 2019. This is the meeting I am referring to. Were you at this meeting?
Yes, I'm no longer sure, Advocate Bauer, because I keep notes. I'll have to go back to my diary for that year and for that date. That will clearly tell me, because most of the meetings that relate to the investigations, as a chief investigator, I'm always there, but I'm no longer sure with this one. I'll have to verify it.
Okay, so we'll add that
going
to
through,
this.
Yes, I'm going through my notes as we speak even.
Right. Now the letter says, and this is where I took you earlier on and you were not sure about this. The minister confirms that during the meeting, the PPSA informed her that a copy of the secret report was purportedly delivered to their offices by unidentified persons, which is therefore patently unlawful. It must be emphasized that the PPSA had not brought the unlawful disclosure of the classified information to the attention of the relevant authorities in the compliance with the Protection of Information Act. Do you see that?
Yes, I'm looking at it.
Right. And then it goes to paragraph 3 of the letter, which is where I was initially wanting to take you. It must be emphasized that the former Minister of State Security, Mr. Mataboge, requested the former IGI advocate Efra Debbie to conduct an investigation into media allegations leveled against the Special Operations Unit and or other branches of the SSA on 26 August 2014, pursuant to media articles published in the City Press on 10 August 2014. And then it says, the IGI does not have a legal mandate to investigate the South African Revenue Services, SARS, in terms of the Intelligence Services Oversight Act 94, and SARS-related activities could therefore not have been commissioned by the former Minister of State Security. Do you see that?
Yes, I see it.
During your investigation, did you check this legislation?
Yes, I thought we did, but maybe at a later stage, not at the beginning when we're getting responses.
Okay. Do you agree with that as a matter of law, that the IGI can't investigate SARS?
It's a matter of law, yes.
Okay. In paragraph 4, it then sets out the law, and I don't want to waste time taking you through that. Go down. Okay. And the essence of this letter, if we go to it, is that the minister then says that she doesn't go down. She's not giving the public protector the report. Go down. And she then says to the acting Director General of the SSA to urgently conduct an investigation into the unlawful disclosure of the classified information. And in the last sentence, the PPSA is requested to cooperate with the investigation to be initiated. Go further down. 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 Go up a bit. I want to read paragraph 11. In this letter, the letter says in the last sentence, in the absence, the rules do not specify the security measures to be employed by the PPSA and would constitute reasonable steps to safeguard confidentiality. In the absence thereof, it is advised that the PPSA employ the following security measures. Go down. The report must be handled in accordance with the standards prescribed in the MIS at all times. The report, as well as any copies thereof, must be surrendered to the minister within 3 days of the date thereof. Its contents must not be disclosed to unauthorized natural or juristic persons, and the identities of all persons who had access to or sight of the report at the offices of the PPSA must be furnished to the acting Director General of the SSA within 5 days of the date thereof. You were aware of this letter at the time it came, correct?
Yes, I was.
Right. And Mr. Nemasisi was at that stage the senior legal advisor. Correct?
Yes, yes, correct.
And you were asked to assist in the preparation of a response. Do you recall that?
I don't recall that exactly.
Let me take you to 5808 of the bundle. Go down to the bottom. On the 20th of February, there's an email to the Chief of Staff, yourself, Mr. Nemasisi, and Ms. Mogolade, and Ms. Baloy, and Mr. Satauli. And it says, legal services, can you get a legal opinion from SC about this matter? They now blame PPSA for not reporting receipt of the report and violating the Protection of Information Act. It says, prepare a response to Minister and inform her that she is not assisting at all in performance of my mandate. I subpoenaed the report and we agreed at the meeting that she will send the declassified report and now come with such threats. The letter is also contradictory. They say we must return the report, on the other hand advise how to store the report. All officials who had access to the report have top secret security clearance. And then the PP says Rodney, COS, PA, and myself. She asks Pona, you have top secret security clearance, right? And then mentions 5.3 of the PPA Act, immunity provision. I disclose that we have the report instead of only informing that Newsweek published the report. Go down. Okay, go up. All right. Now in this email, stop, go down. Go back to the email down. There we go. The PP says all officials who had access to the report, and you included in that list. What is your comment on that, Mr. Mataboge?
I still maintain, I would bow that I didn't see the report. I don't know what it looks like even now.
Okay, go up on the email. There's then a question from the public protector, Rodney, who else had sight of the report. Did Jabulu see the report? Who's Jabulu?
Jabulo was an investigator under my supervision. Jabulo, yes.
It also says, also did Pona see the report? That's Ms. Mokhaladi.
Yes, that would be her.
Right. There's a response to this email. Afternoon, PP. No, madam, he didn't see the report. Even Ms. Mokhaladi, I'm not sure if she did. Subsequent to it being given to me by Mr. Kabinde a few days after the meeting, I put it in the safe. Now, what did you say you were putting in the safe, Mr. Mataboge?
Now I need to check what report was referred to really here.
Mr. Mataboge, whether I'm asking you questions.
No, let me finish because all along, even now, I speak with conviction that I did not see the report. But now that this is appearing like this, I need to really check what report it was. Because I've been maintaining and I still maintain that. So unless I forgot what the report looks like with the passage of time, but what these emails are showing and saying, they indicate that I did see the report, yes.
In the ordinary course, Mr. Mataboge, we're talking about a classified report that ordinary people wouldn't have ordinary access to it. And I have asked you on several occasions during this, did you have access to this report? And it has import, Mr. Mataboge, because it filters into the SARS unit report that is then issued and which is subject to review by the courts. And so I'm asking you to be very careful and to think about this and to tell the committee whether you had this report or not.
Now that it's appearing like this, it means I had the report myself. Because that's why I thought that I tried to remember in my memory what it looked like really, and for me to be able to say I did see the report, but it doesn't come to my visual memory.
Mr. Mataboge, I can show you what the report looks like, but I'm suggesting that you did have the report because that's what the email says.
Yes, then I agree. I mean, this is clear enough that I did have sight of the report because these emails and a trail of emails confirm that, yes.
Now, you're the chief investigator. There's a classified report that is provided to you by the personal assistant of the public protector. Would it be reasonable for this committee to assume that you actually looked at this report?
Yes, I would have.
Let me then take you to page 5821. Actually, maybe go to 5808 first. Sorry, people. Oh, no, sorry. Go to 5821. Right. Go down to the bottom. Mr. Nemasisi provides on the 20th of February a draft letter for the public protector's consideration. Do you see that?
Yes, I'm looking at it.
Okay, go up. And the public protector then responds, and you include it in this mail. And right, and she says, off the draft, she comments on paragraph 3, and she says, the allegations that I did not brought the unlawful disclosure of the classified information to the attention of the relevant authorities is incorrect. The subpoena and discussion during our meeting was to bring the matter to your attention, and you said you'll investigate how the report leaked. And then she says, as I was still awaiting a copy of the report from the minister to verify the authenticity of the report brought to my attention, and she tells him to delete that paragraph. You see that?
I see that, yes.
And then in paragraph 6.4, the following members of my office had access or sight of the report in question, and all of them have a valid top secret security clearance certificate, and she tells him to delete those names. You see that?
I see that.
Your name is at
That is where now I
6.4.
see.
Right. And then she says, I do not want to meet with the request, the declassified report by 25 February, 19 April is too far. So these are amendments that is being made to the letter which Mr. Nemasisi drafted. You see that?
I see it. I'm looking at it that way. And
Ms.
now
Go down.
my comment would be that it confuses more now if my name is being deleted, and I was not sure if I had seen or not seen the report, so it confuses me further.
No. This is a deletion on the letter which the public protector presumably does not want to disclose to the Minister of Safety and State Security. This is the letter that Mr. Nemasisi drafts if you go down at the bottom. So it's not the deletion that you haven't seen, it is a deletion to a draft letter that is in circulation at the moment.
Sorry. Chairperson?
Pause, Advocate Bauer. Advocate Mpofu.
Yes. No, I just wanted to know what is the source of that evidence now, as to what the deletion was.
Let's just hold back, Advocate Bauer, so that Advocate
Mpofu,
Mpofu
I'll give
can.
you
Is not completed. Please conclude, Advocate Mpofu.
Yes. No, thank you, Chair. I was just saying that I've been following up to now, and I think the witness has pointed out to the fact that his name was supposed to be deleted, and I don't know by who or for what, but Advocate Bauer seems to know. So I wanted to just to know what was the source of the information about who was deleting what, for what reason and all that, because we just see the word delete there. But she seems to, I'm sorry, Chair, maybe I'm wrong. She seems to be suggesting who was deleting what and for what reason. Maybe I'm wrong.
Okay.
Sorry,
Thank you, Advocate Mpofu. Advocate Bauer, please take a step back. You're disturbing the chair. Thank you, Advocate Mpofu. I now hand over to you, Advocate Bauer.
Chair.
She's now responding, Advocate Mpofu.
No. I'm sorry. No. I was just checking if you can hear me because my screen has just gone blank. No, that's fine.
No, I can hear you. I can hear you.
All right, I'll try and get back to you to the meeting properly. Okay. Yeah, I'm back. Thank you.
Advocate Mpofu, after this, I'll give you the references to it, but I am jumping ahead because of time, and so I'm cutting out. Let me just put it back on the screen, Shepo. On the at 1751, Mr. Nemasisi provides a draft letter for her consideration. Then there is a response from the PP to this letter. And what I didn't take you to on the is the letter itself, which I will, if you don't have it, Advocate Mpofu, you will then see from the draft letter, it contains these paragraphs, and this is an instruction on the letter to do that. Advocate Mpofu, I'll clarify it with you, but I'm moving off this now. So the source is the actual draft letter that contains these paragraphs that's been amended.
Thank you, Chair. I'm happy with that.
Okay.
Okay, proceed, Advocate Bauer.
Right. There is also then I think it's just go to 5819, Shepo. Okay, there is the draft letter that is provided, and if you go down, no, it's not that one. Sorry, I'll have to just find the actual reference. My apologies, Advocate Mpofu. I thought I'd be able to do that. There is then are you aware of what transpires after that in response to the letter, Mr. Mataboge?
No, I'm not aware.
Okay. You're not included in several emails after that, so I don't want to take you through those things that you may not have knowledge about. There is then a legal opinion received. Are you provided with a copy of that opinion?
If I were to know which one, because I'm not sure.
It was an opinion emanating from whether the Minister of State Security could do what the minister could say to the public protector, what was said in the letter of the 20th of February.
If I may have sight of it to refresh my memory, I'm not sure.
Okay, let me just take you there. It's bundle F. It's item number 96 redacted. Shepo, you with me? And it would be hold on, I'm just looking. If it's there. It would be 2123173. It says dispute with SSA over secret document. That was the heading of the opinion. Two 1.173. Just show the heading of it, Shepo. Let's go down a little bit. There we go. Stop. Does that ring a bell?
Not sure.
Okay. If I then take you back, what emanated after this was a drafting of papers against the Minister of Safety and Security. You were involved in that?
No, I don't think I was. That
Okay.
would be legal services.
You were then, were you involved in the drafting of a statement to open up a case against the Minister and the IGI for refusing to avail the report? Let's go to 5832.
Chair, can I take advantage of this pause to ask for that reference of the opinion?
Go ahead. Yes.
Please, Advocate Brown.
There's 296s in the bundle. The one is redacted, but you've got the unredacted version as well, Advocate Mpofu. It's 2123.173.
2123.173.
173.
Thanks.
Right? Okay. You then I then want to take you back to the report, Shepherd, go back to the SARS unit report. Now it would be 7. You can close 96. Yeah. 216.
Slow tempo. Are we getting there? Thank you.
Go down to 9.3. It's further down. I'm sorry, I don't have it. 9.3. We see that
Yes, I will vow.
that relates to the remedy in the report, right?
Yes.
The Minister of State Security must within 30 days from the date of issuing the report and for the approval of the public protector submit an implementation plan, and the IGI, sorry, Mr. Mataboge, these are not the right paragraphs. Just give me a second. Shepherd, go to 5834. Sorry, it would be if 5832 bundle F 190. Yeah. Go down. Okay, stop there. Stop there. If you see there, Mataboge, on the 11th of March, CEO, which would be Mr. Mashlangu, right? Request Jonathan to assist with engaging SAPS Brooklyn to open a case against the Minister and IGI for refusing to avail the IGI report, which was subpoenaed. Rodney to assist in drafting statement as to when did we send the letter subpoena and meetings with IGI and Minister. Do you see that, Mr. Mataboge?
Yes, I do, Edward Bawa.
Okay, so you were involved in assisting in drafting of a statement. Is that so?
No, not really. Not really. I was providing the dates to the draft of the statement as to when the letters and the subpoenas and meetings took place. Just that.
Okay, so if we go down, just scroll down. Right, down. There's a draft notice of motion and an affidavit, which you're not involved in drafting, you tell us, right?
Yes.
Now go down to 9.3 of the draft provided. Yes.
Yeah, good.
Right. And in the draft, it states that during the first week of January 2019, my office received a report dated 15 February 2014, which purports to be a secret document compiled. And we know all of this, right? So the
Yes.
people tells him about this. We know that now we know that the anonymous report is coming in on the first week of January 2019 when the office received it. And then go down into 9.4, stop there. Having received this document, I could not assume that the document was authentic. On 8th January, I addressed a letter to the Inspector General, Dr. Dintwe, advising him of the two complaints I had received on 8 November and requesting confirmation of the existence of the document I had received and requesting a copy of such document, if it existed. I attached PP1, a copy of this letter. Right. That was the letter of the 6th of January that you had drafted, Mr. Mataboge. Do you recall?
Yes, the one that there was in an email from Mr. Nyembe, I believe, regarding
That's
the
right.
letter.
And you will also know that at that stage, you didn't know about this document at all, correct?
Yes.
But in 9.10 of this draft affidavit, it says that the underlying reason for the subpoenas, right, was a desire to expedite my investigation and to ascertain for myself whether the document submitted to my office was what it purported to be. Do you see that?
I see that.
All right. Now, you're not aware of anybody having authenticated this document that you put into the safe. Do you recall that?
No, I wasn't aware of anybody that may have
Authentication.
authenticated it.
No.
Yes.
Now we go back to the report, Chepo, and we can run through this report very quickly. Right. Now, Mr. Mataboge, you will know that this report had a twofold objective. One was the violation of the Executive Ethics Code by Minister Gordhan, and two, an investigation of allegations of maladministration, corruption, and improper conduct by SARS. Agree?
Correct, yes.
Right. And in the report, you indicate which allegations form the subject of the investigation and which do not.
Yes.
Right. And what is included in the subject of the investigation is what I refer to as the SARS unit and what the PP's office referred to as the rogue unit. Correct?
Not sure about that.
You're not sure about what?
I was saying PP refers it as a rogue unit, you refer it as a SARS unit. I'm not sure about that.
Okay, so let's forget about that. Let's not get bogged down in the detail. The SARS unit is the one that is the subject matter of your investigation as I defined it to you early on. The one that Mr. van Lochenberg was the person who was alleged to have been the head of this unit. Do you see that? Go to V 220 of the report, please, Shepo. No, you haven't got the right version. The report starts at 216. So now you go to 220. So the first part of the investigations, so that we're on the same page, Mr. Mataboge. The first one is the investigation into Mr. Godan misleading the National Assembly. The two is the allegation that during his tenure as SARS Commissioner, Mr. Pravin Godan established an intelligence unit in violation of South African intelligence prescripts. Right? And it's this intelligence unit that I'm referring to as the SARS unit.
Yes.
Right. So B, C, D, E, go down. And F, no, and E, sorry. They relate to this intelligence unit. F relates to Mr. Pillai's qualifications.
Yes, I see that.
Right.
Yes.
Now, Mr. van Lachenberg was said to be the head of this intelligence unit. We discussed this earlier on. You knew this.
Come again, Edward Bauer.
Mr. Mataboge, at the time of your investigation, Mr. Johan van Lachenberg was said to have been the head of this intelligence unit that you were investigating.
Yes.
You agree with that?
Yes. Is that a question or are you telling me?
No, I'm asking you. Did you not know that?
Was at the time of identify the issues, we're still going to investigate that. So
I'm not sure I understand you, Mr. Mataboge.
because when we get the allegations, if it's there in the allegation that he was part of he was head of the unit, it becomes obvious at the beginning of the investigation. But sometimes we uncover it as we continue to investigate. It becomes information that is evidence material of the investigation. So I wouldn't want, because here that's when we identify issues for investigation.
So you knew that he was alleged to have been the head of this intelligence unit?
If he was mentioned in the complaint, I would have known he was the alleged at the beginning. I'm not sure if it was then became known to us during the course of the investigation. That's what I'm trying to say.
Okay. Now, in this report, and if we go down, you refer to a number of reports and opinions, right? In doing that, just go down that. You refer to a number of reports and opinions. Let me list them. The KPMG report, the Sikakani opinion, the opinion prepared by Tringrove and others. Do you recall that? They all listed in your report as a source.
Yes, I do recall. I do recall that with power.
Right. Did you investigate the contents of these reports, or did you simply take what is contained in those reports?
We did not investigate the contents. We were using them as reference and gleaning information from them, because it would have meant that we investigate afresh what they had already investigated.
So you didn't conduct any of your own investigations?
We conducted our own investigations, but not the investigation as per the content of the report, as I understand you to be saying. Because you said, did we investigate this report? We didn't investigate the report. We investigated matters that related to the service that would have appeared to be in those reports, not necessarily redo or review the reports themselves.
See, there was an so let me get this understanding. Did you regard the Sikakane report, the KPMG report, and the ones you relied on as being binding on the public protector?
No, not really, because what would be binding on the public protector was not, what we considered at the time, but we were looking at facts that would be proper and factual for us to be able to write a report and conclude on it.
Okay, I ask you this because in the response to whether you considered the Nugent report or not, the answer that was given was that the Nugent report was not binding on the PP. And so I'm trying to juxtapose that with the other reports as to whether those were binding on the PP and whether you regarded that to be the case.
No, not really. Even these ones were not binding on the PP, but nothing precluded us from using the Nugent as well as using these reports as references or as material for the report.
Right. Now, okay, that's fine. There was then a subpoena that was issued for Mr. van Lachenberg to appear before the public protector under section 7.4. Do you recall that?
Yes, I do. On the 8th of
If we
April,
go to,
I think.
Yeah, I'm not going to take you to the subpoena. I think we can accept, and you accept, that there was an incorrect address on the subpoena. Do you agree with that?
Yes, I would then.
Right. So if we go to page 223 of the report, in paragraph X, it says, during the investigation process, I being the public protector, also tried to subpoena information and documentation from Mr. van Lachenberg, but to no avail, as his last known residence has new occupants allegedly having relocated some years ago. Right. Now, who ascertained that that was his last known residence?
I think the messenger was then, as told by the neighbors, that that was that's where he was last seen. But I don't think the statement is correct to say it was his last known address. If I may comment that way here. So I think it doesn't read well. You should have read that that was the last place where we as investigators were told he resided by the neighbor.
Now, Mr. Mataboge, you sent the neighbor, you as in the PP, sent the messenger to an address. And if we're going down that road, then I'm going to have to put the subpoena up. We'll see it at Rule 53 record, which is item 9 of bundle E. It's at page 108. It's part of the supplementary record, Chairman. Go to bundle 7, item 9. Go to the first supplementary rule record. Go to page of the 1083 of the PDFs. Yeah, it's a fake address, so it's fine. Right. Mr. Mataboge, there's an address on the subpoena that says number 9 Leadwood Crescent, Moraleta Park. Now, number 9 Leadwood Crescent, as it stands here, doesn't exist. Would you agree with that?
With hindsight, I agree with that. But when we got the address from SARS, this was the address we got from HR when we asked for the address. With hindsight, I'd agree that it was incorrect.
Who got it, Mr. Mataboge?
I think Ms. Nguyana, we asked for the address from SARS.
You see, Ms.
From the
Viana,
HR.
Ms. Viana doesn't say she got it from the supervisor or from the PP. That was what she said to us. And that's why
Then I'll have to check as a supervisor how we got the address then after power, because we've not just put the address there.
in fact, the steps taken to trace or follow up on efforts to trace Mr. van Lachenberg has provided to us in the document, which at 4980 that you don't know says supervisor or PP called a SARS employee who provided us with the address. There was no contact for Mr. van Lachenberg as all documents removed from personnel file at SARS. Did you make a call to anybody to provide you with an address?
No, I don't remember.
So we'll ask the PP who she called if it wasn't you. Right? Did you have an opportunity to look at the affidavit that Mr. Linda, the messenger, did?
Come again, everybody. I didn't get that.
Have you had an opportunity to look at the affidavit that was obtained from Mr. Linda? Mr. Linda being David Linda, the messenger at your offices.
No, he hasn't shared it with me. I haven't seen it.
Well, Ms. Ibrahim provided you with some documentation, isn't that so?
Yes, he did.
Did you consider that documentation at all, Mr. Mataboge?
Yeah, I went through most of them. There are many of it. I went through most of them, yes.
Yeah, I know. Let me take you to bundle D number 29, page 4532. This is an affidavit we obtained from the messenger. And he's the messenger driver at the office. And he was tasked to deliver the subpoena to Mr. van Lachenberg during the investigation. And he says that Ms. Mbuyana inquired about the subpoena in November 22 and nobody else had asked him about it thereafter. Had you ever asked him about it afterwards, Mr. Mataboge?
I'm the one who was even asking him more about it, more than Ms. Mbuyana, if I may say.
At the time, Mr. When are you referring to in the time?
Throughout his return, I remember he at some point was saying to me, he's still having the document in his personal file because he's waiting for PMDS. PMDS is the performance management reviews for him to use it there. So I had been continuously asking him, not telling the truth by saying I was not asking him about it.
Now I'm trying to ask when you asked him about it, before he took the subpoena out or afterwards?
The moment he came back, I kept on asking for the return of the subpoena. Then he said to me he was keeping it for PMDS, so that the moment he's done with it, he'll make it available to us. And subsequent to that, I continued asking for it up until we did the Rule 53. And that's when then I said to him, if it doesn't bring it, he'll then have to do the affidavit. I think Ms. Mbuyana will testify to that I was involved in pursuing Mr. Linda about the return of service.
If you go to paragraph 5, I don't think it's necessarily inconsistent with what you're saying, but let me not give evidence. He says, I was requested to serve a subpoena at Mr. van Lagenburg at that address. Before I went out, Mr. Rodney Mataboge inquired from me whether I had already served a number of subpoenas relating to the same matter. Hence, I knew he was investigator. Right? He then says, before I go out, I verify the address. And if the address is incorrect, I usually tell them, but by checking this, I save time. He says there was no Leadwood Crescent, but rather a Leadwood Crescent. Right? And he also says he didn't tell you about the error. He then just went to Leadwood Crescent to serve the subpoena. When he goes there, he finds a complex called Camelot. And on the exterior wall was written number 9 to another number that he can't remember, reflecting the units inside the security complex. And he then describes that he speaks to a man in a wheelchair that manages the complex and who leads him to believe that Mr. van Lagenburg no longer resides there. And he goes in to number 9 in the complex, and he gets told that there's an Indian family living in the complex, but that he could try but not be able to find Mr. van Lagenburg. And that he's left with the impression that the caretaker knows Mr. van Lagenburg very well. So he leaves and he doesn't serve the subpoena. He then goes to the office, he goes onto the internet, and he looks him up and he sees that he's a former employee of the SSA and a former employee of SARS, and that he's appearing in court or would shortly be appearing in court in Pretoria. So he takes the view that he could be served with the subpoena as he would be at court. He then says, I orally reported that Mr. van Lagenburg was not at the address of service to the responsible investigator, Mr. Rodney Mataboge. I asked him where he got this address, and he told me he got it from a former employer, SARS. I told him that he no longer stays there. I also told him that the information I had received, it would be difficult to find Mr. van Lagenburg, and that he was appearing in court and would be best placed to find him for purposes of service. To do that. Do you agree with this, Mr. Mataboge?
I wanted to interject there to say, when did he say engage me on this? When did he say he did this? But I see there's no date in the address, but I don't agree with it.
So tell us
he never
what
engaged me. He never engaged me even on having done the internet search and the Google map and all. He never, all those I see for the first time. I hear for the first time on his affidavit.
Chairperson?
Was Advocate Bauer? Advocate Mbofu?
Sorry, Chair. If I'm not imposing too much, I'd like Advocate Bauer to just read the whole of that so that we don't have to go back to it, because there's just one sentence that she left out, the last sentence.
Okay.
I'm sure
Can I
it
read
was
the
not.
last I go from?
Thank you.
No, just one sentence that you left out.
Okay. I was sure I found the correct place because I was told that he used to stay there.
Thank you.
I thought I said it earlier on when the caretaker said that. All right. Sorry, Advocate Mbofu. Right. So, Mr. Mataboge, just tell me what you disagree with.
I disagree with the fact that he says he discussed with me after coming back that he did Google Map search. He also did an internet search where he discovered that Mr. van Lagenburg was going to appear in court and that he could be served there. I never got to discuss with him that part. The only person that had told us about the court was the PP, not him. I deny what he says there.
Yeah.
Good.
Sorry, you don't have to echo if you agree or don't agree with the witness. Please mute Advocate Mbofu.
Are you talking to me?
Yes, you said.
I'm sorry. Sorry, Chair. Yeah.
And there's somebody else also who said, yeah. So please mute.
No, I don't speak Afrikaans.
Yeah, I know it's not you.
Okay, thank you.
Were you aware that Mr. van Lachenberg, you were aware that Mr. van Lachenberg had been, Mr. van Lachenberg and Mr. Pillay had been facing criminal charges?
I answered earlier on that, Advocate Bauer. I said I became aware on the news.
Right. If you're facing criminal charges, you would be appearing in court. You would know that. Let's assume there's a difference of opinion between you and Mr. Linde, but you would know that they would have had to appear in court if they're facing criminal charges. Would you agree with that?
That is obvious, Advocate Bauer. But I deny the fact that he says he discussed it with me. That's what I'm denying.
Mr. Linde, for purposes of this says, in order for me to have served the subpoena, I'm going to paragraph 15 in the document, to have served Mr. van Lachenberg the subpoena at court, I would have had to have been instructed by Mr. Mataboge to do so. I didn't receive any such instructions. And then he says, I do not have any knowledge of steps that would have been taken to get hold of Mr. Lachenberg before the subpoena was issued. My task is limited to serving the subpoena. And he says he had no further involvement. So when did Mr. Linde tell you, or when did you become aware that the subpoena wasn't successfully served?
I think, Bauer, my answer would be, let's defer this question to Advocate Ms. Mvuyana, because as my subordinate, she was the one I was sending from time to time to Mr. Linda's office, because what he's saying here is not correct.
Okay, but the point isn't a procedural one as to when you send Ms. Vuyana back and forth to Mr. Linde's office. When were you finally told that they didn't serve the subpoena and Mr. van Lachenberg is not at that address?
The day after he had served it, because I wanted a return of service.
Who informed you thereof?
Mr. Linda, because he's the one who had gone there. And I said to him, can I have a return of service? Then he said he still wants to retain it so that he may put it in his file for PMDS, which I said earlier. And then that's when I then continued thereafter to ask for it from him, to an extent that I even want to check with HR files for the year, whether indeed it was part of the evidence, because we use those things as evidence in the PMDS files. Now that is becoming a big issue for us here as a committee and as the investigation team.
So the day after the unsuccessful service, you knew that Mr. van Lachenberg could not be found at that address, right?
Yes, because he told me.
What did you do?
No, normally I didn't do anything, but normally when we get such, we just file it and then we're not like the subs Bauer. We don't look and go search for people. We then record that we were not able to serve a subpoena eventually in the report, but we alerted the PP that we could not serve the subpoena because Mr. van Lachenberg is no longer at that address purportedly, and that's when the PP then advised about the court appearance.
Thank you. Just a pause. I see a hand. Advocate Mpofu.
Thank you, Chair. No, this is just a quick one, Chair. I wanted just to check, seeing that if there's this dispute, whether Advocate Bauer intends to call Mr. Linda so that we can take instructions on what to do to resolve that dispute.
I'll think about it, Advocate Mpofu, and we can chat about it later.
Okay, thank you, Chair.
Okay.
Thank you. Let's proceed. Thank you, Advocate Bauer.
Okay. So, in other words, Mr. Mataboge, as investigators, you did nothing further to find Mr. van Lachenberg.
Yes, correct.
You didn't even look on the internet to see if he was there. You didn't look on anything Other than that, you didn't consider checking through Home Affairs or the traffic department, nothing. You just did nothing.
No, we didn't, I didn't, because I remember Ms. Viviana said she tried to search on the internet and she was unsuccessful, but she's coming, she can talk to that.
So in the document that's provided to me or to us, the response was given, we don't have at the time, the investigator did not have full access to methods of tracking an individual. Do you know what that means?
No, I wouldn't know what it means.
What methods of tracking of an individual would the PP have at her disposal at that time?
I don't know. I don't know. How would one be tracked, except maybe like you say about internet search. But formally, I don't remember there being any way that the people would be tracking individuals. Except maybe through Home Affairs. And
the PP has vast powers under the Act. She could access this through a number of government bodies to be able to obtain information of an individual that is required for purposes of an investigation. Do you accept that?
Yes, about the PP powers, yes, I accept it.
Over and above that, were you aware that Mr. van Lochenberg's attorneys had been in touch with the PP's office?
No, I wasn't aware, and I said that previously. I was not aware.
Yes, I'm aware what you said to me previously, Mr. Mataboge. When an attorney represents a client, then it's reasonable to assume that that attorney is able to contact that client. Would you agree with that?
Yes, I would.
And even if that attorney doesn't have authorization to accept service on behalf of the client, you wouldn't know that until you ask the attorney if they can assist you in locating the client. You would agree with that?
Yes, of course.
Right. Now let me take you to page 5911. It's a document of the 14th of June, 2019. Are you aware that the report gets issued on the 5th of July, 2019?
Is it the 5th? Yes, the 5th or 7th of July. I'm not sure about that. But it's July.
It's the first week of July. Let me, somewhere there, right?
Yes.
On the 14th of June, just go down, Chepel. There's a document that is provided, correspondence from which is for the attention of the public protector, and it's a demand for publication of false and defamatory statements regarding Pillay and van Lochenberg. Go up. On the 15th of June, you are included in this, Mr. Mataboge, a note attached from Webber Wentzel attorneys on behalf of Ivan Pillay and van Lochenberg. Do you see that?
Yes, I do.
So you are given the correspondence from the attorneys of Messieurs Pillay and Lochenberg. This is 3 weeks before your report is finalized.
Yes.
And if you go up, you are party to the correspondence from the PP where she instructs Yenego to respond and to deal with this letter. So you knew full well
Yes, I see that.
You were in possession of the correspondence from Mr. van Lochenberg's attorney before finalizing the report by the PP.
Yes, I see it now. I see it.
So you could have, if there'd been a will to want to find Mr. van Lochenberg, to do it.
I don't agree with the part about the will, really, because at the time, it was in June, the subpoena was in April. And at the time in June, we had already issued 7 nines to the parties that were directly in case of implicated parties or affected parties. They had already been served with 7 nines. And the subpoena was in April. We never thought, I particularly, never thought that we could still serve him the subpoena even in June after April, May, which was almost 3 months down the line.
Did the timing matter, Mr. Mataboge? He mattered enough that you issued a section 7.4 to get him to come and give evidence to the Public Protector's Office. You needed his information. You had all these allegations which had been made. He was alleged to have been the head of this unit that you were going to find to be unlawful. Did it matter whether it was 1 month or 2 months or 3 months prior to the report being issued?
I hear your law. I no comment on that.
In fact, you assisted in finalizing a response to the Web of Venture letter, correct?
No, I wouldn't have. I'm not sure. Then my memory doesn't serve me if I assisted. But I'm speaking under correction. Yes.
Yes. The reference would be 6327 at 190.2.
And as you go to that reference, we are now at 1530. So please go to your reference.
Chair, I'm not going to the reference. I'm going to need a bit more time. I've got to go to the remedy in the report. I don't do this often, but it's a difficult witness in the sense that I don't have a statement. So I'm going to ask the chair for an indulgence for me to finish off the SARS unit report, and I can then maybe ask Mr. Mataboge the questions relating to Busasa in writing. But this I can't do in writing. I just wanted to show him 6327 at 190.2.
I'll give you an extra 10, 15 minutes.
So, Mr. Mataboge, Mr. van Lachenberg was clearly a person of interest, and he was also implicated in the remedy of this report. Do you agree with that?
I'm not sure. I don't remember exactly on the remedy. Can we go to it?
Just let me. I'll take you there in a moment. I'm going to come back to that. I'm going to take you to remedy, and I'm going to come back to the I'm going to take you back to the remedy. Let me just take you up to the report first, so if I can. Oh, I'm going to lose something out of that. Mr. Mataboge, I put to you earlier on, I said to you that there were 3 things that you looked at in the report. One is the legal opinion of Advocates Strengrove and Kumalo. The second thing was the Sikakane report, right? And the third thing was the KPMG report. That's evident from the report itself. Were you aware, or you had been informed, that the KPMG had shifted away from its report in this regard, that they had issued a media statement questioning the veracity of their own report? You were aware thereof, correct?
Yes, yes, I became aware, but I'm not sure whether it was after or before our report was issued, but I was aware of that they are shifting, yes.
It was provided to you as part of the Pillay pension investigation by Minister Gordhan. if that rings a bell.
Yes, if you say so with power, then it means it was provided before.
All right. And there's no mention of that made in the report. In fact, that was one of the concerns which the court had in its judgment. Correct?
Yes.
Right. If we go to paragraphs 5.2.25 at page 263 of the report, you record that the Sikakane report recommends that the activities and functions of the SARS unit be investigated by the IGI, and it records that Dr. Dintwe confirmed that such investigation had occurred and confirmed the existence of the unit at the meeting of the 31st of January. That's page 263, Sheppel. You see that?
Yes, I do.
You must go, all right. And then you say into the PP says in 5.226 that that she was reliably informed of the custody of the report. But I want to say to you, Mr. Mataboge, and it's only fair that I put it to you as well, that having read the transcript and listened to the recording, that nowhere in the recording does Dr. Dintwe confirm that there had been an investigation of the SARS unit or confirm the existence of such a unit at the meeting of 31 January 2019. Do you want to comment on that?
I won't comment if you say so, unless I have to go and listen to it, but I'm not denying that if you say the transcript says that.
So if it's not assumed for purposes of the question I'm putting to you like that, if it's not evident from the transcript that they had provided such confirmation, where would the contents of these paragraphs have come from?
Can you repeat the question? I'm trying to digest it. I'm not getting it.
Okay, if I'm correct, if assume for purposes of the question I'm putting to you, that the minutes and the transcript of the meeting and the recording of the 31st of January do not bear out that Dr. Dintwe had confirmed the existence of the SARS unit or had confirmed that there had been a previous investigated allegations of the intelligence unit within SARS. If I'm correct with that proposition, then where did the information in 5.2.25 and 5.2.2, well, 5.2.5 come from?
If I need to answer you, I need first to check the transcript myself and even my notes, because I was in that meeting with Dr. Dintwe. And then I can be able to provide a reliable answer on what you say.
Okay, we'll make sure we'll give it.
I don't disagree with you, but I don't think this information will just come from us as investigators and be put here.
Then if we if I then take you to the question on remedy that I asked you about earlier on, you see, Mr. Mataboge, as we see different drafts emanate, the remedy in drafts become more clearer to the investigators and the PP. Would be a fair assessment to make?
Yes, that is correct.
Right. And so if you look at page 642 on the 1st of July, this is a few days before the report is finalized. Six, 428. 6428 of. Come on, 190. I'm running out of time here. Right? So this goes forward. So let's go to 6409. Sorry, we've been there already. No, 4936. My apologies. Start over. Okay. You prepare a report, Mr. Mataboge, and then you have a meeting with the public protector. On the pursuant to this, and what I'm now taking you to is 4936 is your minutes of your discussion. You're gonna have to go to 189. No. Didn't say. Four, 5. It's 4936. Right, it's one of the 189s. Yeah. Got it. Okay. Mr. Mataboge, you provided some of your handwritten notes to us.
Yes, I did.
Right. And this is a discussion of the draft with the public protector in which you refer.
No, this is not. This is Ms. Mbiana's note. I don't write like that. My handwriting is worse than this.
Okay, I was for a moment impressed with your handwriting, but right. So this is let me then not take you there because that's her handwriting notes, and take her there to do that. Right? Can I then take you to 2 further questions that I'm going to ask the chair for leave to ask you afterwards. In the Busasa matter, right? Sorry, Mr. Mataboge, I must ask you this question about remedy before I do that. Chair, just bear with me, and then I've got literally 3 questions.
You have 3 minutes for them. Thank you.
Mr. Mataboge, if I go to pages 6, 5259. No, 5259. Do it like this. Yeah.
5259.
Um, 649, no. 6538. Yeah. Okay. If you go to 7 point, go up. Go up. This is the draft of the report that's been provided to us of one of the things where the recommendations or the remedial action is. And I want to take you down to the remedial action in respect of the Minister of State Security in 7.3.1. All right. There it says the initial relief the remedy was sought that in with 30 days of the report acting in line with Intelligence Services Amendment Act, commission an investigation by the IGI on the current status of the unit for any continued breaches of the Act by individuals or organizations and take the necessary appropriate action as provided for by the enabling legislation. That is not the relief that is in the final report. Do you agree?
Yes, because this was still a draft.
It was still a draft, right? And if you go down further, you'll see that there's two other, the only relief sought in respect of the IGI was that within 30 days of this report, conduct an investigation into the existence of the unit and verify its continued existence through audit of the assets and equipment which had been sourced for its unlawful activities and caused to account for all assets for purposes of its disposal itself. Now, can you recall how the draft ended up being what it was in the final version?
I don't recall, but in the normal circumstances, there would have been perhaps comments from the PP to the team, or the team have redrafted and submitted to the PP, but I'm not recalling exactly how you have changed. But it takes a lot of toing and froing before a final product is signed by the PP or approved. So I wouldn't recall exactly.
Now, in respect of Kusasa, I'm going to put this to you and I'm going to ask the chair for leave to put the question to you in writing, but I want to put this to you at the proposition. The nub of the dispute is what was the meaning of what was 2.3 of the Executive Ethics Code and which was the correct version. In short, that was one of the issues that arose during the litigation. Do you agree?
Yes, I recall. Yes, I recall that, yes.
And whether it was deliberately and inadvertently, or whether it was, what's the other word? Willfully, right?
Willfully.
Now, in your drafts that is prepared initially on the Rule 7.9 leading up to it, willfully is used throughout, and then it gets changed to deliberately and inadvertently. And I want to know if you know how that change came about in the drafts.
But like I just said, even though I'm speaking from memory, it would have come from engagements with the PP and myself as an investigator and agreeing on that perhaps. But because Bosasa was one what I can't call it a crucial report, it was one sensitive report, it would have meant that we would have had to agree on that as investigators with PP. But I'm not sure. I'll have to check my facts on that one, because before a final draft becomes a final, I mean, the draft become a final product, I exchange a lot, or we exchange a lot of those with the PP. So I'll have to check my drafts, which are still in my laptop, many of those, to a point where then I'll note when did it then become the changed version. in terms of the dates.
And then, I mean, Chair, I can't, there's way too many questions that I still have on the further investigation. It's going to be a pointless exercise for me to endeavor one or two.
Okay, we will end it there.
Yeah, but I am going to ask leave to submit those follow-up questions to Mr. Mataboge in writing to the extent that I can't deal with it with Ms. Vianney when she comes.
Okay, that's okay. Thank you, Advocate Bauer. We'll take 10 minutes break and we'll resume at 4. Thank you.
Chair,
Recording
okay.
stopped.
Welcome back, colleagues. We had a very short tea, hopefully, and it's not concluded. We're still going to conclude that. Let's resume our work.
Can I wear my jacket?
Mr. Mataboge, are you there?
Chair, I'm here, but we are just about to be hit by load shedding in 2 minutes or so. I'm worried that it's going to interrupt us, Chair, but I'm here.
Yeah, no, it's fine. Thanks. I hope that generator will work. Thank you very much. We now change gear, and I'm now going to invite Advocate Mpofu to interact with you. Advocate Mpofu, over to you.
Thank you very much, Chairperson. Chair, I was trying to catch your attention before the break, but I think we're already gone. I had just wanted to say that, or rather to propose that Advocate Bauer be given the amount of time that she needs, because she has not covered 3 of the reports that she mentioned at the beginning. So I know how it feels having it happen to me with Mr. Pillay and Ms. Basani Baloyi, that where the questions are not finished. So I don't think it serves the purposes of the committee just to do that, just in the interest of fairness. But Chairperson, the other reason, and maybe the reason why I was going to make that suggestion, is because, as you have now indicated, the reason why you made that restriction on her is obviously to try and give us the opportunity to do the cross-examination. And it was to indicate that in any event, even if Ms. Bauer were to go on until 5, or even tomorrow, whatever time she needs, we are not in a position to do the cross-examination anyway. So it will serve no purpose to curtail her for the remaining hour. And we were going to request anyway that our cross-examination be deferred till whenever it's convenient, sometime next week. And if I may finish then, Chair, also because well, if you want me to motivate, I will, but maybe let me do so just to save time. The grounds upon which we make that request, Chair, is exactly what Advocate Bauer is caught into now. I think for all of us, this is new territory. It's the first time that we have a witness who has not made a statement. And we almost had a similar disaster last week. And while we may not force a witness, and we all tried in fairness, both ourselves and the evidence leaders, I think, and even the Secretariat tried to convince this particular witness to make a statement to somebody, whether it was us or them or whoever. But he, in the exercise of his rights, said no, unlike Ms. Mviana, as we know, who had actually indicated otherwise. So that's the first major obstacle. The second one is that, of course, there are now new documents that have also emerged, which in any event we would need to deal with before we do any cross-examination. There's the document that Advocate Bauer promised to WhatsApp to us. Third thing is that there is this issue of Mr. Linda, who, as Advocate Bauer indicated, we'll have to discuss offline, me and her, because one of us looks like is going to have to call him, whether it's us or her, we can discuss. But I think it's only fair that the committee should hear from him, seeing that there's a dispute between him and Mr. Mataboge, because Mr. Mataboge would have had an advantage of being here and being cross-examined. And therefore it means his evidence must be preferred to the untested evidence of Mr. Linda. which would be unfair on Mr. Linda. Then the third issue is, of course, what I've already mentioned, which is that the Advocate Bauer has not led evidence on some of the crucial evidence, or rather issues such as CR17, Busasa, Pillay, and to the extent, I don't think Friede 2 is that important or relevant. So let's stick to the two that are important, which are Pillay and CR17. And then, of course, there are also, lastly, Chair, there are aspects on which the witness has kept on saying he will check or bring evidence or look into this or that issue. So all in all, even if we started the cross-examination, it would be seriously handicapped and not helpful to the committee, and certainly prejudicial to the public protector, given these unique circumstances. So all in all, Chair, I'm making 2 points. One is Advocate Bauer, in the interest of fairness, should not be subjected to what we were subjected to, which is an unfinished witness, because some of that evidence might be important. But secondly, in any event, we were going to request you to grant us a period to defer the cross-examination for later. And maybe, Chair, before I sit down or move back from that, I can refer you to the relevant provision in the directive.
No, that's fine. That's fine. Advocate Mpofu.
3.6.3. Have you got that, Chair?
I've got that.
3.6.3. I think, Chair, I know it's going to take time, but let me just read it for the record. It says, yeah, the exception to clause 3.6.2 above relates to witnesses subpoenaed to appear before the committee as provided for in the Powers Act, who may not have rendered any sworn statement, such as Mr. Mataboge. In relation to such witnesses, the evidence leaders shall present the evidence from such witness through questions to the witness, underline questions to the witness, whereafter, and should such be required by the public protector, the latter may request that cross-examination, if any, be postponed for a period not exceeding 5 days. So that's the provision of the directives that we are invoking. And also, therefore, on that basis, then Advocate Bauer should be at least maybe given the remaining time for today, or whatever time she needs. Thank you.
Thank you, Advocate Mpofu. Let me quickly respond to those issues. Firstly, this is how we operate, and I've said this before, and I will maintain it with her, Advocate Bauer. We operate on time and not how much Advocate Bauer has not covered. If she is not able to cover things on the set time, it becomes her challenge to deal with. I've said that to you, I've done that to you. She is no exception. There's time that has been allocated to her, and I would have reminded her 3:15, 3:30, and I extended that to 4:45. The fact that there were 3 other areas remaining, it can be a challenge for us stretching and making this elastic. We can't operate like that because it is not sustainable once you do that. At what point? Because then it gets to be to issues of propensity, the pace, and so on. So if you've got somebody who takes 10 minutes on an issue that takes a 1 minute, then you are in trouble. We can't operate like that, whether it is Advocate Bauer or Advocate Mpofu. So I maintain that she's been given the time. In her allocated time, she's gone up to that point. And so I maintain that consistency. and you're correctly saying it was applied to you, it's being applied to her today.
Yes.
I get it. I get your second. Please don't disturb me. I'm on the platform.
Apologies. I just wanted to say 2 wrongs don't make a right, but
No,
I'm
no,
not-
please don't do that. Please don't do that.
Okay, sorry.
Thank you. There's a second point you're raising, which itself is very significant. When you say that either this remaining hour today or the rest of tomorrow, that you are not prepared for cross-examination. It's a different matter altogether. So that's what you're submitting, that you're not ready for cross-examination. Even if I were to give you this hour, even if we will say prepare overnight, you're not ready for cross-examination. And given the fact that you're not ready, you're invoking our provisions in the directive, very fair. In doing that, the directives are for that. We're not going to overlook them. But they are also very specific in terms of the period. If we're to delay any matter or matters, and you've just quoted that. Today is Thursday. So if you're talking about 5 days, we know that there's an immovable property on Monday and Tuesday, which is Bianca Singobile Mvuyane. We know that on Wednesday, we have, and the 2nd of March, we have Advocate Madonzela appearing and submitting a testimony here. So if you look at next week, it's only Friday, a day that you can play with, which means not doing it this Friday. If we're to follow those directives, we then are going to settle for that Friday, not any other day, because we wouldn't want to stretch it any time beyond that. I'm going to put it to members so that because for the reasons that the time that has been allocated has been exhausted, and the next slot is not able to come in. If it is a view of them that we can use the remaining 30-45 minutes and allow Advocate Bauer to conclude, because we're not going to peg her for the next Friday. I'll hear if members are amenable, agreeable to that. Otherwise, that's what I want to say as my first take. Honorable members. Honorable Hilo Isdena, followed by Honorable Maneli.
Thank you, Chair. Now, I think
and Honorable Ngosi.
if we go with that arrangement, I think we should give Advocate Bauer the opportunity to conclude, because she did mention that she still has a few questions. So I think we should go with that. Thank you, Chair.
Thank you, Honorable Maneli.
No, thanks, Chair. I think I've been firstly covered on the points you've made earlier, and I think we should agree that it's on the basis that Advocate Mpofu may not be prepared to proceed from this point, and you need to consider the directives, as you said, they can be reviewed now. It's a matter to look at, so I thought it's important that we support you on that, but also that Advocate Bauer can continue. But I'm not sure if I heard her well, that she's also not asking for few days to come, because she has put in a provision that in a case she's not able to, that she's taking leave to submit further questions in writing, right? But that's probably something you may rule later on. But I just thought it's important to take note of that so that it's not open-ended, even in that.
Honorable Ngosi, Honorable Maneli, Honorable Ngosi.
I think I'm covered. Maybe just to make the point that we are taking this decision on the basis of the second proposal, not on the fact that questions have not been exhausted, etc., etc. We're taking on the basis of what he submits as his second reason, and without creating precedents, because I foresee that the same will happen with, or may happen with, the next witness.
Thank you, Honorable Nkosi. I think you just clarifying a matter here, which I stated quite clearly, because I was very upfront that Advocate Bauer has what was initially allocated to his time, has utilized that. The pace she was not successful to do in covering other 3 areas, I was not entertaining that. And so if there was not the second proposal, it was never going to be considered. She was never going to come back to complete that. Let me be abundantly clear on that. I've put it to you only because of the second proposal that says I'm not ready this hour and tomorrow to do cross-examination. And therefore, because the integrity of our program therefore remains as we have revised and agreed to. It is not, doesn't get affected in that. Are we agreed, members? Thank you. Honorable Sakulele Zipho, I know so betty late.
No. I just wanted to check whether your ruling says it's not precedent setting.
Thank you for that amendment, Honorable Sakulele Zipho, so that it's very clear. This is not how we're going to proceed. We've not been proceeding in that way, in any way, as elaborated by Advocate Mpofu here as well. Advocate Bauer, do you want to complete?
I understand.
My hand is up.
Oh, okay. I see your hand now.
Thank you, Chair. So I don't want to, as it were, give with one hand and take with the other, and now take away from Advocate Bauer's time to ask the question. So, Chair, but I think I have to clarify a few things. Not a few things, just one or two. The reason why I raise the issues conjunctively or one against the other is exactly because they are related, as you correctly point out, Chair. And they basically would motivate for Advocate Bauer being granted the extra time, which I appreciate. But I just want to make it clear that this, I don't want to use a wrong word, fixation, I think is a better word there than obsession. Yeah. The fixation with what you call the integrity of your timetable. If, as what I'm hearing from the members, it is meant to override the interest of fairness, then it's a very dangerous path to follow. Because yes, we have an integrity of the program, but we also have fairness and reasonableness. And so I was placing it on the issue of fairness. So, and also to emphasize the point I was making that 2 wrongs don't make a right. So if you deprived us of a fair chance to complete witnesses, it doesn't mean that we must perpetuate it. And so this idea about precedent setting and what have you, I think it will be a sad day if this committee wants not to set a precedent of being fair. Thank you.
Thank you, Advocate Mpofu. Advocate Bauer, as I hand over to you just to summarize, I had stopped you because the time allocated to you was complete. The meeting was scheduled up until 5 o'clock. You are being brought in so that you complete that time. It is indeed not a precedent setting. Don't expect it to happen again simply because we did it today, because there's a reason we're doing it. Thank you. Advocate Bauer, please conclude. Go ahead.
Chair, I understand Advocate Mpofu wants me to continue cross-examining, so we'll take it from there. Chair, I
No,
may still
I
not
don't.
finish, and then we have to ask the investigator. I would then still have to ask for certain written questions to be put to the witness. But Mr. Mataboge, are you still with us?
I'm here with Bawa. I'm here.
Okay, I want to take you to page 6409. I'm going right to the bottom of it, Sheppel. The 3rd of July is a few days before the final report in the SARS unit is finalized, and the PP appears from a different email. Can you identify it, Mr. Mataboge? Just go up here. It's a private email. Sorry, it's not there. It's the PP's private email. Okay. And she tells you to put corrections into the report. Do you see that?
I'm looking at it, Bawa.
Right. And I want to take you to the second paragraph, which she advises you to re-look at Labello's affidavit on this part and juxtapose it. All necessary and relevant information, especially on Project Sunday evening, must be considered. On secret purchase of equipment, check Labello's affidavit also. And then she says to you, and an emphasis that the content of the memo to Trevor by PG and Pillay by itself is an admission that they knew that SARS does not have legislative powers, but SSA. But it's not clear what they continue to form it anyway without SARS. Go down. She then says that sorry, just give me a second. All contravene the NSI Act, and it is a criminal conduct. Another remedial action, Minister of SASA must release the declassified IGI report. Come get my comments to clean up the document tomorrow morning. Did Advocate? I'm sorry, I read it wrong. In the middle of it, and it's not clear what they continue to form it anyway without SSA. Sorry, that was my error. Mr. Mataboge, I want to make the point that here again, reliance is placed on the Labello affidavit for information to be put into the report. Do you see that?
I see that, Bawa, yes.
And you were instructed to have a look at it.
Yes, I see that, Bawa.
And in all probability, you did. Would you agree?
Yes, I would have.
Just a pause for members. I'm not going to be breaking for tea, but tea has arrived, so you can grab it as you just sit down, and I'll in a few minutes make an announcement. Proceed.
You then, if you scroll up on the email, you will see that go up. Up, yeah, right. You noted go down. Oh, sorry. So I'm going to read it to you because now Advocate Mkabani's private email is on the document, and we're trying to avoid putting it up on the screen. Advocate Mpofu, so if I don't show it, that's for that factor. But so in view of PP's directives today, you then asked for more time to clean up the document. And she then tells you that the report is being issued on the 5th of July. Do you recall that, Mr.
Yes, I do. I do, with Bawa, I do.
Right. So these are changes that are made a day or two before the report is finalized. Correct?
Yes, that would be the case. Yes.
Okay. You then at 6428 you are providing her with an earlier version in which you tell her that you are incorporating right. You tell her that the most recent drafts of the proposed remedial action and guidance, and you are finalizing it and you're doing a quality assurance on the draft. And she is then looking at it, right? You don't yet, if you look at 6443 and 6444 of the draft, which, yeah. If you go down, you're busy putting in the summary of the recommendations on this version. Do you see that?
I see. Yes, I do.
Right. And if you go further down in it, actually, you start putting in the documents that you had regard to further on with highlighted paragraphs. So all the changes on versions that you send back and forth between you and her, you highlight the changes that gets put into the document. Would that be a fair way of characterizing the method of operation?
Yes, that would be fine.
Right. Now, after the report was taken on review, to what extent were you involved in the finalization of affidavits?
After it was taken on review at Ubao.
Yes.
You mean the PPs whose affidavits? I need to get clarity on that.
The PPs. So let's take this so that we're clear. The review is brought of the report. Are you given a copy of the papers?
Yes, I get a copy. Yes.
Right. The answering affidavits are then drafted for the PP by the legal team and probably the external counsel that is appointed. Are you provided with an opportunity to comment on the answering papers?
Yes, I do. Sometimes I even get to be asked to be part of the meetings if we need to consult. Yes.
Right. Now, in the SARS unit report, if we go to 5969 on the 14th of November 2069, the PP specifically asks you to give feedback into the answering affidavits into the review application. Do you see that?
Yes, it's give input. Yes.
Right. Did you do so, Mr. Mataboge?
I would not really remember. After each time the legal services have already drafted, they shared with me for me to agree or add anything that I needed to add. So I wouldn't actually remember exactly if I made specific inputs on this one, but they give me that opportunity every time it happens. Yes. So then I'll have to check what was my contribution in respect of this one.
Now, one of the issues raised when Mr. van Lachenberg came to give evidence here was that he had deposed to an extensive affidavit and no issue was taken with the contents of that affidavit. The PP did not deny it. The PP didn't deal with the allegations contained in his affidavit. And he says his affidavit was undisputed before the court. Do you wish to comment on that?
The affidavit in response to the review.
Yes, he was one of the deponents in the affidavits filed in support of the review of the application.
Yes, I wouldn't make any specific comment there because that was the area of the legal services, but I didn't make input to what he had said in response to his affidavit.
Now, so you would have read the founding papers, you would have seen the allegations made by Mr. van Lachenberg, and they remained unchallenged.
That's what it would mean up until I see my input, if I made any at the time I ever get down.
Okay. Now, let me take you to the Vrede matter. Your position had been that you didn't look at the first Vrede report.
Yes, that has been my position, yes.
Right. Now,
that is the Vrede 1 report.
The evidence that supported the various findings in the second report, I'm going to say to you, were available and accessible to the PPSA, even when they did the first report.
I can't comment on that.
Okay.
I can't comment on that. So on the first report, I was still not involved now.
Right. You referred in the second report to the outer report.
Yes.
Use that in one instance as corroborating evidence that the Guptas had paid for Zwani's trip to India, in fact, in the report. Were you aware that the outer report had been available to the PP during the first Vrede report as well?
But I wouldn't say that because we sourced that information ourselves. The senior investigator who was dealing with it sourced it herself. We didn't get it necessarily from the first evidence file. We sourced it ourselves.
The first evidence, the first report made no mention of it. The report had been provided to the PP, but not, it appears, to the investigators during the first period. So you're saying you didn't get the report from the PP?
Yes, because we had to engage with several people who were involved, subpoena them, and I believe even in this one, we sourced the information ourselves as investigators, not necessarily from PP.
So your second investigation focused on issues such as prejudice to beneficiaries, excessive spending of government funds, and undue benefits to Estina. Would that be a fair summary of it?
I'm not sure, because for us the primary focus was the politicians' involvement in the project and their lack of oversight and holding whoever was responsible for the project accountable, if I'm correct, if I remember it correctly.
So the political involvement and the possible prejudice to beneficiaries, those were the two things you focused on?
Yes.
You didn't investigate and report on the excessive spending of government and the undue benefits of Estina. My apologies, Mr. Mataboge. I think that's probably the correct way to put it. Would you agree with that?
Yes, I agree with that, yes.
Now, in the first report, there were 6 uninvestigated issues that was highlighted. One was cattle deaths. Did you look at cattle deaths, Mr. Mataboge?
I wouldn't say we looked at it necessarily, but we had to go and meet with the beneficiaries. And they in their statement talked about the death of cattle, but we didn't even go to the project itself. So I wouldn't say we looked at it specifically as investigators, yes.
Right. So
our worry was more, our worry was particularly towards the prejudice to the beneficiaries that we met on the day, and to hear them out and assist them.
You see, there were 6 issues that stood over from the first report. The one was cattle deaths. The 2 was issues from the third complaint. The third was value for money. The fourth was the Gupta leaks. The fifth was how Estina spent their money, and 6 was the beneficiaries. And it seemed of the 6 things that stood over from the first report, you actually only dealt with one of those issues, which is the beneficiaries. Would that be correct?
I don't know why Advocate Bauer is using the word that stood out or stood out that because we were not part of the initial report. Then I wouldn't know why the word stood out for me doesn't sound okay, because when we started with the investigation, after it was decided that we deal with the investigation, it was narrowed to the political, which had even been as a result of Parliament, some committee in Parliament being addressed by the PP, asking about the role of politicians in the project. So we didn't even look into the issues that may have stood out as you refer to them that way.
And so you're saying that the second report emanated solely because of the intervention of the Portfolio Committee of Justice?
I'm not sure if I was correct, because the interaction between PP and the committee is the one that then came with the conceptualizing or the need to reinvestigate the matter.
Okay. Now, for purposes of your second investigation, you interviewed Mr. Magashulu, Mr. Zwane, Ms. Kabathe, Ms. Rockman. So they were the former agricultural MECs, the former finance MECs, the former agriculture HOD, and the former executive mayor of Pumelele. Whether you did it or somebody in your unit did it, right? Now, the question I'm going to ask you is, did you interview the beneficiaries?
Yes, we spent the whole day at Friele interviewing the beneficiaries.
And did the beneficiaries come and speak to you voluntarily, or did you need to subpoena them?
No, we did not subpoena them. We invite them to a meeting in their own territory to go and understand their continued dissatisfaction and prejudice. So we didn't need to subpoena them.
Right. And you held public hearings, I understand. Is that correct?
Yes, if one were to call them public hearings, because we're in a hall with all of them, yes.
And you used the beneficiary list that had been compiled by the municipality?
Yes, it was provided to us by one of the beneficiaries who was a leader of the group, yes.
And this was actually the same beneficiary list that had previously been provided to the public protector during its first investigation. Do you know that?
No, I wouldn't know that.
And
I
you were
wouldn't know
able,
that.
and you were able to obtain both oral and written submissions from these beneficiaries and their survivors, correct?
Yes, because those that could not write, we had to write for them, and those that could write made written submissions. But mostly our investigators were the ones who were taking statements from them.
How many of you went, Mr. Mataboge? How many of you attended to the meeting with the beneficiaries?
I'm counting. I'm keeping quiet because I'm counting.
You can take your shoes as well.
We're 4 investigators that attended, aside of the spokesperson and the PP, and yeah, there were 4 of us.
And how long did it take you?
We spent the whole day there.
One day.
Yes, one day.
And you interviewed the beneficiaries. You didn't really speak to the complainant, Mr. Jenkelson, at all, eh? I think you said that to me this morning.
No, not at all. Yes, not at all.
And would you have an idea of what this exercise cost the PP's office financially?
What exercise is it about?
The exercise of going to Vrede and speaking with the beneficiaries.
I wouldn't know. I wouldn't know that.
Right. And this information you sourced from outer It was very relevant to the.
No.
Advocate Mpofu.
Yes, sorry. Yes, Chair, my hand is up.
Yes, Advocate Mpofu.
Chair, I have to object to this evidence because on the basis of relevance. As I indicated when I addressed the court, the committee earlier, we could understand, and that's why we were even pleading for Advocate Bauer to be given an opportunity. We could understand the relevance of the Pillay report and the CR17 report. But she's now left with 15 minutes or so, and she has spent the time going back to the rogue unit and now canvassing a report which is completely irrelevant to this committee, which is so-called Friday 2. And Chair, well, I'm making this remark or this objection on which you must rule on the basis that of our observation, which I will deal with when we do our cross-examination, which is that it looks like this whole exercise is not about dealing with the charges or the issues or the reports that are relevant to this committee. It is rather an exercise that is solely aimed at the sanitization or cleansing of Mr. Pravin Gordhan in relation to the rogue unit, or in the Catholic Church, they call it beautification. We are not interested in the beautification of Mr. Gordhan. We'd like to deal with the issues that are relevant to this committee. And this is not one of them, Chairperson. So please, I can't dictate to Advocate Bauer how she wants to use or abuse her time, but certainly I can object to irrelevant material. Thank you.
Thank you, Advocate Mpofu. Let me hear Advocate Bauer.
Chair, one of the motivations given for some of the investigations that had not been done during the first report, that had been done during the second report, was precisely that one of financial constraints and an inability to be able to go out and actually deal with these beneficiaries, apart from the fact that they waited and waited and waited for somebody to provide them with these details before they go. They did this with relative ease the second time around. And I think that's materially relevant to the assessment of the investigation the first time around.
No, I'm sorry, Chair, sorry. May I come in, Chair?
Yeah, I have not ruled. Yes, you can come in.
Yes, very quickly, Chair. No, I know the time is against us, yeah. No, I understand what Advocate Bauer is saying. All I'm saying is, let's assume all what she's saying is true, that she's trying indirectly to show that 2 years before the beneficiaries were available. I don't know how she proposes to do that, but that's fine. That's her prerogative. But, or that if there was no money at in a particular year, then when there's money in another year, then you can't do an exercise. And that's just a futile exercise. But that, again, that's her prerogative. The point I'm making is that all that, it's not relevant to the charges. The charges before, on which I understood her to be leading this witness are 11.3 and 11.4. And that's got nothing to do with beneficiaries or whatever. It's whether the investigations were done independently and impartially and so on, and whether they were done to shield certain people, blah, 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 in 11.4. So it's irrelevant anyway, even if what she's saying now is true. The Friday 2 report. Thank you, Chair.
Thank you, Advocate Mpofu. Advocate Bauer.
Chair, I've responded as to where and why I was going to the second report in the context of the motion. I mean, Advocate Mpofu can argue that if he wants to.
Okay, that's fine. I'm going to rule that we continue
and Advocate Bauer continues to interact with the witness.
Okay,
So-
thank you, Chair. We'll go with the flow.
You concluded from your interviews, public hearings, document reviews, that there was political involvement in the Vrede project. Am I correct?
You are correct, Edward Baum.
And that politicians were unduly influenced by persons linked to the Guptas.
I'm not sure about that narrative.
Okay, well, it comes from, I'll give you the reference and I won't take it there. It comes from the 2020 report, page 10, para Roman numeral 16, small a, capital A, double C. And there's a number of findings that you make in the report as to the guilt of the officials in respect of maladministration. Correct? And a failure to fulfill their constitutional responsibilities.
Which officials are with power? Because
Ones that-
we investigate.
Now, let's just say the ones that you investigated and in respect of whom you make findings in your report, the conducts of Monsieur Zwane, Tabete, and Kabathe.
Yes, those were the politicians in our view, yes.
That's right. Okay. And you also imposed a remedial action for purposes of assisting the beneficiaries. Correct?
Correct, Edward Baum.
PP did that.
Yes, because we, not necessarily because as a team, as an investigation team, as we've been seeing with regard to the SARS unit, we engage with PP on the remedial action. She doesn't just do it on her own herself.
Now, in terms of the Vrede report, during the course of this investigation, the public protector had said to you that you must consider certain reports. I put that to you early on in the day that emanated from the first investigation. Is it your evidence that your team didn't look at it?
I didn't look at it. I can't say my team did not look at it, and for the reason that I advanced, yes.
Now, the complaint in the Busasa matter, it's a question of legal interpretation. Let's deal for the moment the ambit of whether or not the public protector had jurisdiction to investigate the CR17 fund or not. But the question as to whether the president had deliberately, willfully, or inadvertently, whichever version you want to put, depending on the report and the judgment, it's a question of interpretation. Would you agree?
Yes, I would agree.
And one would then have to assess the facts, look at the relevant law, and come to a conclusion.
Yes.
And it would have to be a law that is in force. Would you agree?
Yes.
And so there would be a fundamental difficulty if the law was not in force.
Yes.
And it was so, Mr. Mataboge, that there had been other instances in which reliance had been placed on a provision of the code, which the Constitutional Court then found was not in force. Do you recall that?
I recall that, but only as far as when it was said that the PP or us as the PPSA who had inserted certain words into the code, if I recall.
Yes. What had transpired is it turned out that there were two codes, one with the force of law and one without. Would you agree with that?
I wouldn't agree with that because there was the one that was in the handbook, and there was the one that was in the, I think in the code itself that was not in the handbook.
Yes.
And the wording the wording in both were different, if I recall. Yes.
And the one that had been passed and gazetted would be the one that's in law, and the one that has not been done so would not be the law. Would you accept that? In fact, we've had a ruling of the Constitutional Court on this. So that is now the law, correct?
Yes, Sir Bauer, if you say so.
No, I'm.
Chair.
Advocate Mpofu?
Yes, sorry, Chair. I'm sorry. I know the time is up there. Two quick things, Chair. I wanted to request Advocate Bauer, maybe just to make this easy, to refer to the codes by the IES, the 2001 and 2007, I think is one of them. But also, Chair, I just wanted to appeal because we've had some very disturbing images from the Zoom from one of the members. If something that looked like blood or whatever. So we don't know what the problem is, but it's disturbing to some of the members of my team. So if members can just be careful not to switch on the camera if they are involved in any bloody mess. Thank you.
Thank you, Advocate Mpofu. Just Advocate Bauer.
Mr. Mataboge, I'm saying to you that when you prepared your drafts, there is the code that existed from 2007 and which the Constitutional Court relied on as the law. And then there was the 2007 code, which we understand was at some point attached to the ministerial handbook. July 2007.
Yes, Sir Bauer.
Yes. Right. So let's get this right. The July 2001 is the promulgated one, and the 2007 version is not the promulgated one.
Yes.
Right. Now, you would accept that if it's not promulgated, it doesn't have the force of law.
I would accept that, but before I accept that, I would want to refer to our previous MER reports that had been issued and acted upon, which, in my view, as far as I recall, had used the very one that we use in Busasa, word by word, if I recall.
Yes, as Advocate Mpofu pointed out to us, two wrongs don't make a right. We accept, Mr. Mataboge, that the 2007 version had been used in previous reports, and I don't think that is an issue here. The question I'm posing to you is, when the affidavits, I want to know when the affidavits were prepared for the Constitutional Court, did you provide input into these affidavits? And I'm referring specifically to the public protector's affidavits.
Just like the earlier ones, I would have been asked to make inputs, and definitely I would have. And if I deemed it proper and where there was a gap, I would have participated in that. But not necessarily that in all of them I would always have to, or that I would have been able to make inputs because they are prepared by legal services.
Right. And the question I asked was, did you? You say you would have, but you're not sure as you're sitting there whether you did or not.
Yes, I'm not sure. I'm not sure because there were several reviews that we had to go through.
And were you involved in the decision after the Constitutional Court judgment was handed down to seek a rescission and reconsideration of the judgment?
Oh, I wasn't. That is the terrain of the legal services people and the PP there.
So I have 5 minutes left. Let me take you to the one other issue that arises in the report that I didn't touch on. One of the issues that arise in the SARS unit report is whether or not Mr. Pillay has a matric certificate or not. Do you recall that?
Yes, I do recall.
Right. And there is a debate about, or there's a dispute that arises about whether this information had been provided to the public protector before hand or not. Can you recall anything in respect of that?
No, I don't recall anything that relates to beforehand.
Well, you had an interview, let me be more specific. There was an interview with Minister Gordhan, and having looked at it, the transcript, it doesn't appear as if Mr. Gordhan had indicated that anything in the respect of Mr. Pillay not having a matric certificate. Can you recall that?
I can't recall that, but I'm not sure if what you said, you show off it yourself, because is a transcript available? Can we have a side of the transcript?
Let me see if I can find this. It might be one of the questions, given the time available, Mr. Mataboge, that I put you in writing with a proper reference, because it does seem that it's a bit more too complicated for the time I have available to ask you that question when you do that. In respect of the investigations, did you ever encounter any third parties not employed at the Office of the Public Protector specifically being involved in any of the investigations or in the settling of any of the reports?
Even in the past, but that would have been when there was backlog and some investigation would have been outsourced, and some of them would have been insourced due to the backlog that was occurring in the office. But that would have been done within the parameters of RFQs and proper allocation and proper tendering. If it was needed a tender, people would also come and have briefing sessions. That would have been outside investigators, other companies like SNG and others that would have been appointed.
Now, let me ask this specifically in respect of 3 of the reports that form the subject matter of this motion, in respect of the SARS unit and the EMEA complaint, in respect of the Pillay pensions case, and in respect of the Busasa matter. Other than your investigative team and the PP or any of the staff in the employee at the Public Protector's Office, was there any other individuals involved or providing input into the reports?
No, not to my knowledge, Advocate Bauer. Not to my knowledge at all.
Mr. Mataboge, on the last minute, we asked you certain information yesterday. Did you have an opportunity to respond to it or to look at it? In particular, have you found the investigation diary relating to the SARS unit?
Yes, I did, David Bauer. I must start by proving to you that there was a challenge with that file of the SARS unit, because when we were doing the Rule 53 and the admin and everybody was dealing with it, they had to go and get it from registry, and that's why it was difficult for us to get it. So we managed to get it, yes.
So you have the investigation diary of that. Can we arrange for you to send it through to us?
Yes, we can arrange.
And Chair, I'm in your hands. How would you prefer the other questions to be answered? That we've, Mr. Mataboge, would you prefer answering them in writing and then just confirm your answers before the end of your evidence?
Yes, I can do that, Advocate Bauer.
That would be fine. Advocate Mpofu, would that work for you?
No, sir, through you, Chair.
Go ahead, Advocate Mpofu.
Thank you, Chair. No, it won't work for us. And thank you for giving me the opportunity. Chair, we have a problem. Two problems. One is the immediate one that's raised now. The state of our readiness to do cross-examination is obviously directly proportional to the completion of the evidence by the evidence leaders. So until that information is supplied, because if it's supplied, let's say 1 minute before the cross-examination, then we'll be having our own problems with when does the 5 days start to run and all that. But so I think in fixing whatever timelines for the exchange of information, and I suppose we can be guided by Mr. Mataboge as to how long it will take for him to gather that information and give it to the evidence leaders, who will obviously then immediately give it to us. So there's that one issue. The second related challenge, Chair, which I was going to raise anyway, is that your intimation about next Friday is also a bit problematic. One of the reasons we had left Friday open in our backroom discussions was one of two reasons. One was the anticipation that Advocate Madonsela might spill over to more than the allocated time. The second one was also that we had requested the evidence leaders for sufficient time for us to prepare the public protector's statement. So I'm just indicating that there might be a problem if we're going to have three very important witnesses next week, namely Mvuyana, Madonsela, and this witness back to back, then it will affect both of those objectives. I'm just raising a chair for your consideration in scheduling. But I think the more immediate issue is that obviously our time to prepare for cross-examination will only start to run once we've received all the information, or once Advocate Bauer has quote unquote closed her case, her questioning. Thank you.
Okay, thank you, Advocate Mpofu. I think let's do this on this issue of Mr. Mataboge. That Advocate Bauer is going to, from tonight and tomorrow, send whatever you need him to respond to, and that we get that by Monday from Mr. Mataboge, which gives ample time for the PP and the legal team to prepare. That should be how we do it. There shouldn't be any train smash on that particular issue. We're here, we are aware what are the issues that were flagged, including these kind of questions that you raise. So that's the first point in terms of how we do that. We know that Monday and Tuesday is Ms. Mvuyane with the committee, and we've signed off arrangement because the understanding and the request of the PP is that she's going to be here with them next week for those 2 days. Advocate Madonsela is scheduled for the 1st and 2nd of March, and on behalf of this committee, as a chair, would have written to her and indicated the areas of focus. And we are very confident that those areas of focus shouldn't really be spilling over to any other day beyond the 1st and the 2nd of March. It was a very specific and tight in that regard. So I hope, therefore, that helps you, Advocate Bauer, in terms of just being ready to dispatch those outstanding questions for response. And once you do that, it helps also the other team. Which then, once that is done, concludes Advocate Bauer's approach and or action with the witness.
Cross-examination.
Can you mute Advocate Mpofu?
Why do you want to mute me? I can mute my.
Just keep on muting every time.
No, but Chairperson, that is wrong what you're doing. Why do you want to?
Don't do that, Advocate Mpofu. This is a meeting that has a chair that runs this meeting. I don't entertain any unwarranted, uncalled for kind of disturbances that you're doing. Just mute him, please. Just make sure you mute him every time he opens that mic. So that's what I'm indicating, colleagues. And so with the development,
Can't hear you. You muted the chair. You're muted, Chair. I'm not.
thank you. They can hear me. Thank you.
No, we can't hear you.
No, please mute Advocate Mpofu.
Even.
So that's tomorrow is therefore taken out of the system as planned and scheduled, which is something beyond our control. But we're happy to indicate that we're still staying focused to our program, and we'll do everything, colleagues, to stay and keep that integrity of the program. So far, there's no reason for us to really go beyond that. But even this issue that Advocate Bauer is going to deal with the return date on Monday, in terms of our directives, that also applies within that 5-day kind of period. Therefore, it can't go beyond that. Honorable, the meeting is still on. So the next point I just want to address, just as I conclude with Mr. Mataboge, you are still going to be on the stand with your testimony. Unfortunately, not tomorrow. It will be indicated to you when is that last opportunity for you to do that. But as for today, this is where we're going to pause with you as a witness. We thank you so far for being with us and participate. I also, colleagues, before we wrap up, to just it's been brought to my attention that amongst us here we've got visitors. Seeing them sitting there with the Miss Adhikari. These are visitors from the US, if I'm correct. They are led by the Honorable Oliver Gilbert, who I'm told is the chairman of Miami-Dade County Board. That's in Florida. Okay. And that's a team that he's with, who are here to taking this trip on a business visit as part of the cities International Cities Conference. I hope that you will share a lot of the rich experience you have but also you will take away in this developing democracy in this country a lot of the experiences that we have, including challenging ones of how to run coalitions, which is not very much in your space. You'll get that more in Italy and other areas. But you are visiting a committee that is dealing with the issue of fitness to hold office, a first of its kind in relation to what you would know as ombudsman, that we know here as the public protector. It's a novel process that we're dealing with. It's not similar to your Nixon, Clinton, and Trump impeachments, but there are similarities. It's not the same. So this is, if you think about that, this is the kind of committee that you're visiting here. In this country, we've never done an impeachment on a president, never done an impeachment on a judge, but we're starting a process for fitness to hold office of the holder of one of the offices that are helping us with our enriching our democracy. That's the exercise that we have, that we've started in 2022, or even before that. In the next month or two, we're hoping to be coming to a conclusion. Thank you for visiting us, and you are welcome in South Africa, and so you spend as much as you can to grow this economy. And then the next point I want to make is
my hand is up.
Is just mute him. Just mute him. Is a birthday wish for the media person of this committee, Miss Azakani Raja, who has a birthday today, has been locked into this room the whole day. Happy birthday, Aza. I hope now that we're concluding, you will be well spoiled when you get home. And thank you for your role, your performance, and everything you do, not only for this committee, for justice, for this National Assembly, in the different areas that you get thrown into. We really appreciate the role that you play. Thank you very much. Honorable members.
I want to raise a point of order, Chair.
That bring only members raise points of orders, not a person. Just mute him. Just mute him. Thank you.
It's disgrace what you are doing.
So honorable members, the time now is 5:15. This is the point where we wrap up this meeting. Thank you very much. The meeting is adjourned.
Chair, it was another